Application mentioned next week.
May I mention extremely urgent order 41? I mentioned yesterday it has been listed as item 129, but the appellant is a renowned publisher, Devsahitya Kutir, restrained from publishing any work of renowned author Narayan Devnath just before the book fair. Calculatedly, it was
This is a book fair.
book fair 22nd. We couldn't publish Shuktara January edition also because of the injunction. 22nd. Fully printed, we couldn't publish. Huge loss already we have suffered, for the Shuktara. Now book fair start.
Tomorrow it will appear as special fixed at the top.
I'd like to mention FMA 1865.
You mention after the advocates.
My lord, yesterday, my lord, item number 25 was disposed of, but my lord, I committed a mistake, lordship. In place of 11th August 1971, that is the execution of registered deed of exchange. Lordship, it would be 30th April 1971.
Please hand over to be mentioned. It will appear for correction.
May I have your lordship kindly to mention for inclusion of application, my lord, stay application.
Please wait for next week.
My lord, actually, urgency is that, my lord, other side is going to proceed with a contempt application against my client. That is the reason. My lord, stay is required, my lord.
Next week.
I am mentioning, my lord, item number 123 of your lordship says that is, my lord, an application under the heading tribunal application. But this writ petition is filed by the state, my lord, challenging an order of the tribunal where, my lord, I have been directed to hand over the land. But that has not been done. They have preferred this writ petition, no stay order. Now what they are doing, my lord, they have put a hoarding over the land claiming belongs to the state of West Bengal. But I am apprehending, my lord, they might create a third-party interest over the.
There is no interim order. You are for the respondent, no.
My lord, I am for the respondent. There is no interim order, my lord. I have no because the sole.
No. Sorry, no.
Yet to be implemented.
No, not at the instance of the respondent.
My lord, kindly, my lord, some.
No.
May I mention one matter for inclusion in the list for hearing?
Hearing? No.
In the earlier occasion, you have hearing matter about matrimonial.
No.
I heard for matrimonial proceeding.
My lord, mentioning for inclusion, my lord, the new matter, my lord.
What matter?
First appeal, my lord.
First appeal, no. First appeal, there is no scope of any admission. So no question of any new matter. Yes.
My lord, first appeal, my lord, out of an decree passed by the trial court, my lord.
Not right.
My lord, the urgency is, my lord, that the wife, who is the appellant, my lord, suffered from a decree, my lord, dismissal of the matrimonial suit, my lord, during the pendency of the suit, my lord, the time of the judgment, passing of the judgment, my lord. In extreme compelling circumstances, the doctors suggested that she would not be able to conceive, my lord. In the meantime, she conceived, my lord, and she gave birth to a child, my lord. And in the meantime, my lord, this decree was passed, my lord, dismissing her matrimonial suit, my lord. This is the, my lord,
The urgency in that.
my lord, kindly considers, my lord, that, my lord, 10 years of legal battle, my lord,
It's not done.
2015, my lord, the matrimonial suit was instituted.
Inclusion tribunal hearing. The matter is ready for you.
Not right now. Yes.
Sure, a degree has been passed against us without serving summon upon us. So we have filed an appeal under Order 41, Rule 11. But Lordship,
Cannot be. First appeal, we are not. We don't
Lordship,
hear it.
I have filed with the judgment. I filed the appeal.
These are not admitted. Those are deemed to be admitted by the registrar. So there is no order 41 hearing. Sorry, ma'am. Yes.
My lord, may I be permitted to mention a matter? FMA 435 of 2023.
Not right
the
now.
Custody.
May I seek your lordship's kindly to mention a second appeal, your lordship. This was made to go out of the list on account of certain defects that were there. Your lordship, those defects I'm instructed have been cured.
Mention next week.
Your lordship, the urgency I will just attempt to canvass once. Your lordship, the decree that I'm suffering was a suit for eviction. I'm suffering the decree. On 18th, your lordship, the hearing was there. We already passed that date. Lordship, any day, your lordship, I'll
mention next week. Sir.
I'll come
Lordship,
back.
inclusion in the list, Lordship.
What matter?
Lordship, application for the substitute.
Wait for next week. Yeah.
Mention for the application.
Next week.
Yes. I'd like to mention an appeal for inclusion, FMA 18.
Appeal hearing we are not taking.
First miscellaneous appeal, Milord.
No, we are not taking right now. We have too many hearing matters.
Milord, I came before the vacations, Milord.
We understand. With so many, you see others also. So sorry. Yes.
Next
sorry.
one, Milord. May I come next month?
We can't say. It depends on our disposal. So let us call on the list. Yes.
Mr. Mukherjee.
Yes, Mr. Mukherjee, please.
May it please the Lordship, Milord, I beg to appear.
Yes, Mr. Mukherjee, please.
On behalf of the petitioners, with my landman, Mr. Arindam Banerjee.
Yes.
Milord, I have some difficulty in speaking, Milord. I am indicating the point, and if necessary, your Lordship will have the orders placed by Mr. Banerjee. I can't read out, Milord, at length.
No difficulty, Mr. Mukherjee.
I'm just indicating the point, Milord, involved in this matter.
Yes.
Finally, pick up an Estate Acquisition Act and the rules. together with the Land Reforms Act and the rules.
Land
Your
Reforms Act.
Lordship need not go into the brief, my Lord. I'm
Yes.
indicating briefly the point.
Right. What are the
Kindly-
points?
Lord, kindly turn to section 4.
Rule.
Section 4.
Section
of the
4.
State Acquisition Act.
Estate Acquisition Act. Achha.
Yes.
Please wait for some time, yes. So we have it. Yes, Mr. Mukherjee, Estate Acquisition Act. We have
Lord,
it.
Section 4 provides for vesting of all intermediary interests in the state on a specified date.
Yes.
My property also vested according to the government. Now, after vesting, there is a retention under Section 6. Kindly turn to Section 6.
Yes, Mr. Mukherjee.
With a
Retention.
non-obstante clause, which provides for retention.
Yes.
Now, I am a company. Company.
Saregama.
Saregama was previously known as Gramophone Company.
Gramophone Company, right.
Your Lordship will kindly recall your Lordship days in the boyhood days.
Yes.
We used to have long and medium-sized
Long playing and yes.
medium-sized records.
Yes.
This Gramophone Company used to manufacture those celluloid records.
Absolutely, Mr. Mukherjee.
In course of time, my Lord, the tape recording and the tapes came into vogue, and we no longer are fond of those celluloid records.
Yes, in your childhood, we had many record-breaking performances.
Yes. Now, my Lord, with tape recorders and tapes.
Yes.
And celluloid records were out of fashion.
They've shifted to CDs now, and nowadays probably they're taking out these pen drives and all.
No,
Yes.
it's from the net.
But
Straight
the
internet, no pen drive.
Yes.
manufacturing of celluloid records
Yes.
were not profitable, not viable. My company, Gramophone Company, my Lord, had a plot of land, 2 plots of land, together measuring 15 acres and 15 acres plus something, with structures. I have given the detail. Out of these 15 acres, 4 acres was with structures. The company
You retained 4 acres.
15 acres I have retained, 15 plus something.
All right.
Out of these 15 acres, 4 acres were with structures, the company's manufacturing unit.
Right.
Now, with regard to this 14 acres, there are 2 parts. One part was 1 acre plus something. That was the vacant plot of land. The government wanted to get it vested, fought it out in the court. The parties are known as Saregama, because Gramophone Company was renamed as Saregama. Now, one thing was allowed to be retained by the Honorable High Court, holding that this is not with the factory land, it is a separate plot of land, vacant land, they are entitled to retain it. And the factory land, measuring about 14 acres, that was allowed to be retained by the department as an industrial plot. Factory land was allowed to be retained as a factory land, non-agricultural land. I return to section 66 of the State Acquisition Act. Retention is category-wise. In the Land Reforms Act, this is in lump sum retention, total. Here, my Lord, the retention is category-wise. Section 6.
Yes.
Land, homestead, land with structures.
Yes.
I retained it under non-agricultural land category. Total area was 15 acres.
15, right.
15 acres.
Yes.
Later on, I applied for conversion of this land into residential commerce. Kindly tell me, after retention of the State Acquisition Act, I became a tenant under Section 6(2). Kindly look at Section 6(2) of the State Acquisition Act.
Yes, Mr. Mukherjee.
I became a tenant under the State Acquisition Act.
Yes.
Later on, Land Reforms Act was introduced, and under Section 4, kindly turn to Section 4 of the Land Reforms Act.
Yes, Mr. Mukherjee. Section 4.
I became, subsection 1, I became an owner with heritable and transferable right.
Right.
And I came to describe it not as tenant, but Rahat.
Right.
In the Land Reforms Act, there is no question of tenancy.
No.
Rahat. Now, Section 4C, kindly turn to my lord, Section 4C.
Section 4C.
I'm entitled to apply for conversion of the plot from one purpose to another.
Right.
I applied under Section 4C for conversion from industrial to residential cum commerce.
Yes.
Now the authorities, right from the three authorities, ADM, Commissioner, disallowed my application, and that dismissal was affirmed by the Land Reforms Tribunal on the ground that you have retained the land for industrial purpose. Even in the earlier proceeding, High Court has said that the main plot has been retained for industrial purpose. How can I apply for conversion? And against that, I have moved your lordship. Kindly look at Section 4C. Retention is under the State Acquisition Act. I become a Rahat. 4C gives me the right to apply for conversion because I have retained it for an industrial purpose, not that I cannot convert it some other purpose. There may be one case, my lord, we are not governed by that case. Suppose, my lord, Hindustan Motors, there was a manufacturing company known as, which used to manufacture ambassador cars.
Yes.
They retained 1,000 acres. They were entitled to retain only 15 acres. But they retained 1,000 acres. How could they retain 1,000 acres? Kindly turn to Section 6(3) of the State Acquisition Act. 6(3) of the State Acquisition. There was a proceeding under Section 6(3), and the government could allow
Yes. Yes.
more land than Section 15. The ceiling limit of the State Acquisition Act for non-agricultural purpose was 15 acres. They are running a factory. I require 50 acres. The government would allow me the extra land on condition that in the event of your stoppage of industrial activity, the government will be entitled to resume. But if I have land below the ceiling, the courts, if I have land below the ceiling, namely 15 acres, there is no question of Section 6(3). Only in the case of 6(3), I may not be allowed to convert an industrial block into residential or commercial. In my case, then out of 15 acres, 4 acres was covered with structures and 11 acres of vacant land. Supreme Court has held, in the case of land held below the ceiling, there is no question of 6(3) being applicable. Now, the refusal to consider my application for conversion on the ground that I have retained it for the industrial purpose doesn't seem to be legal and justified. This
So
is the point.
you say, Mr. Mukherjee, that if it was written under Section 6(3),
then that question would have arisen. That you have been given relaxation for industrial purpose. You cannot convert it for residential purpose.
But
In
here
my
it has not,
case,
no.
I have not got the benefit of 6.3. This is under the ceiling. Therefore, the question of industrial not permitted to be converted into residential purpose. That question cannot arise.
All right.
Section 4C gives me the right to apply for conversion. Only in the case of 6.3, there may be that consideration. In my case, I have not applied for 6.3. They say, the High Court has said that you have retained it for industrial purpose. True. I have retained it, but 4C gives me the right to apply for conversion from one to another. It may be that you have retained it, the benefit of section 6.3. Benefit of section 6.3. That question would arise.
All right.
This is the point involved, my lord. My lord, it has been held that in the case of land held below the ceiling, 6.3 doesn't apply. Held by Calcutta High Court first, and the Supreme Court has also held. Land 11 acres vacant land, 4 acres with structures. Vacant land 11 acres, section 6.3 doesn't apply. That is as of right I retain it, not under section 6.3.
All right.
This is a short point involved. If the interpretation of the government is accepted, then 4C becomes redundant. I've been given the right to apply under 4C. They don't consider the application under 4C. They say that because I have retained it for industrial purpose, you cannot convert it to some other purpose.
All right. All right. All right. Very well, Mr. Yes.
This is the problem. This is a point involved, Lord. Possibly it deserves your Lord's kind consideration.
Mr. Mukherjee, only one thing. You said that if it was, if benefit of section 6.3 of Estate Acquisition Act was taken, then it would not have been converted.
Yes, that may be done because that is the only relaxation for the purpose of industry factory.
Because
Where
that
there
is
is no
made for the specific purpose that it will be used for that mill or factory or, and here it was a normal retention in your case.
normal as of right retention.
As of
Kindly
right.
look at section 6.3 intact.
Yes, yes, yes. Very well, Mr. Mukherjee.
In my respectful submission, Lord, it deserves your Lord's kind consideration.
All right, Mr. Mukherjee. So then, should we look into the judgment then directly?
Lord, other side আছে কি রে?
Which
No?
was
না নেই
Dear Lord, I was proposing your
Yes.
Lords will kindly admit the matter and keep it for hearing at length at presence of the other side. Otherwise, your Lordship can read the judgment now.
No, Mr. Mukherjee will hear out the matter. State was appearing on the last occasion. State has been appearing, Mr. Mukherjee. If they choose not to appear, we'll just hear out.
Kindly hear out.
Yes,
Please, Mr. Banerjee, kindly
Let
hear
Mr.
out.
Banerjee place the judgment and whatever. Yes.
Kindly place the judgment.
yes my lord
Mr. Mukherjee, on the last occasion when we fixed the matter, was the state appearing? They were not. But it was appearing in a regular course, and we call it in regular course.
yes you
When
called
an adjournment was sought by you, and we
adjournment
fixed the
was sought
matter.
and a prayer was made.
Very well, then move. Let us hear the matter. We'll conclude the matter.
Just good.
Mr. Banerjee, I can't read out. Lord, kindly.
No,
Yes,
Mr.
I'm taking
Mr. Banerjee will do that.
I'll take
Yes, please.
Now, my lord, there are 3 orders which stare at us. The first order, my lord, is the order of refusal. The application is for conversion of the user of the land from its existing factory purpose
Industrial to residential come
industrial to residential come commercial.
Yes.
This application we have put forward in terms of the section 4C of the act in accordance with the rules. There are certain paraphernalia which are required. We've all furnished that. Now it goes up, my lord, before the first authority, which is the DL and LRO, the ADM and DL and LRO. From there, my lord, there's an appeal before the Commissioner Presidency Division.
Both affirmed.
And from the Commissioner Presidency Division, we went to the West Bengal Land Reforms and Tenancy Tribunal.
Yes, yes.
Under Section 6, read with Section 10.
So all three
Affirmed.
authorities affirmed that. The
Affirmed.
reasoning was basically the same as Mr. Mukherjee said.
Reasoning is basically the same.
You retained for industrial purpose, you cannot now convert.
Now, Lord, there's something which I must point out to your Lordship. There, as Mr. Mukherjee had pointed out, there were two segments of land. One is 14.33 acres, one is 1.96 acres. 14.33 acres of land is situated on one side of Jessore Road, and 1.96 acres of land is situated on the other side of Jessore Road. It is my case that these lands which I was holding are automatically retainable under 61A to 61E, mainly non-agricultural lands. My lords know, my lord, that there is a vesting under Section 4. Effect of vesting is all the rights of intermediaries vest in the state. That's Section 5. Section 6 says simultaneously with the vesting, there is a auto retention. This auto retention is the one under which we are claiming. Kindly see Section 6(1).
Yes.
A is homestead. B is land comprised in or appertaining to buildings. Wherever there are structures, that will be out. C, non-agricultural land in khas possession up to 15 acres. D, agricultural, not important for us. Tank fishery is not important for us. Therefore, my lord, insofar as 61A to 61E is concerned, we attract 61B, 61C together. It's our case that because of this, there was no excess vacant land at all. Since there is no excess vacant land, the provisions of Section 6(3) would not be required. That's our submission.
But 14.33 plus 1.96 takes it to above 15.
But then structures and lands appertaining to structures.
Try to segregate the structures.
Yes, they are additives. They can be added. I can take additional benefits of that, and it's clearly beyond.
Right.
But what happened here, my lord, was novel. The government permitted me to retain the land under 6(3). Now, 1.96 acres of the land, my lord, which was on the other side of Jessore Road, there, my lord, a resumption order, my lord, was made by the government. I'll show you, lordship, lord, that judgment. A resumption.
You are permitted to retain under 6(3).
6(3).
Then why shouldn't 6(3) apply?
Because 6(3) is a surplusage. That is what we had contended. Now, my lord, that 6(3) is a surplusage. Now, my lord, government had permitted us to retain under Section 6(3). Now, 1.96 acres of land, that's the land on the other side of Jessore Road, that's the smaller plot of land, the government had passed a resumption order. Resumption order is, they said that you did not erect structures on that 1.96 acres of land, and accordingly, we are resuming back that land.
So both 14.33 and 1.96 were permitted under 6(3).
1.96 was sought to be resumed and possession sought to be taken back on the premise that we had not constructed structures there for factory.
That can only be done if it's under 6(3).
That can only be done if it's under 6(3). So that resumption took place. We challenged the resumption. The matter came up before this honorable court. Before this honorable court, in a reported judgment, Saregama versus State of West Bengal, an honorable division bench, I'll place that judgment, an honorable division bench held thus: 6(3) can only apply to lands where there's an excess requirement and where a factory is operational on the date of vesting. On 1.96 acres of land, that's the smaller tract of land, there was no operational factory on the date of vesting. Therefore, the retention under 6(3) was inapplicable, not required, inapplicable in fact, because that 1.96 could not have been made subject matter of 6(3). Number one.
But that's an afterthought you're having. You took advantage of that at that point of time. You did not.
But that point was decided there. It was point was decided there. In
At the
taking
time of
advantage
presumption,
of,
it was-
yes, in taking advantage, in making this plea on law, we are not gaining anything. It's not as if we are gaining something extra. Number 1.968, if we are out of the 6.3 regime because of 6.1A to 6.1E, and there are judgments.
Say that by what? Because it was in the same process of retention that 1.96 and 14.33 were retained.
Yes.
Same process. 60. It was purportedly under 6.3, but at the time of resumption, this court held that it's not. It was
So that
not under
1.96 acres
was
couldn't
not
be
under 6.3.
attracted by, it couldn't be hit by 6.3.
Therefore,
couldn't be
that
visited.
logic you say should apply to 14.33 also.
As far as 14.33 acres is concerned, that the Honorable High
Did
Court
not.
Division Bench's judgment did not say anything about 14.33.
How do you link that to? Because it was a part of a same retention process.
We say that from the very beginning, 14.33 plus 1.96, and the if contradistinct with the immediate automatic retentions under 6.1B read with 6.1C, we are within the ceiling limit. And this plea can be taken. There are judgments where we have taken this plea and it has been held to be an estoppel not operating against the statute. It's only if I take an unconscionable benefit. I tell you, Lordship, when unconscionable. Mr. Mukherjee has given the example of huger land needed. Let us say, my lord, my factory was on 14 acres of land, but I need 100 acres of land. Sorry, my factory was on 100 acres of land, but I am entitled to retain only up to 15 acres. The balance part, assuming no other thing applies, the balance part, if the government gives me, it can give me under 6.3. 6.3, the government for lands which are beyond the ceiling can afford me the opportunity of continuing with my factory.
But you had more than 15. 14.33 plus 1.96 taken together, you had more than 15.
But if your lordship has to add, my lord, the structural component also.
You say A and B.
A and B are
can be clubbed.
Has to be clubbed. A and B have to be clubbed. That land means land, non-agricultural.
I'm sorry, B and C.
B and C. Yes, A is homestead.
Can be clubbed. Very well. Land component. So if you are entitled to retain under 6.1, then entitled to retain with effect from the date of vesting.
Yes,
land
automatic.
comprised in or appertaining to buildings and structures as well as non-agricultural land. But the same land can you confer both characters while retaining. It's the same land.
It's the same land. Once it has, if your lordship travels down 6.
One land with building and structure.
Yes.
So can you get double benefit 15 plus 15?
Not 15 plus 15. 15 for one. Your entire holding. It might not even be contiguous.
Exactly.
Your entire holding anywhere in West Bengal.
That was more than 15.
That was more than 15. So for non-agricultural, I get 15. That's the vacant land part.
Yes.
And the land appertaining to structures, I get under 6.1.
Can you get that 15 plus this 15 together for the same land?
It is available, my lord. It can be clubbed. It's just like Urban Land Ceiling Act. Wherever there are benefits given, these benefits, my lord, are addable. They are summable. It's not as if which one of the two would prevail. There is no special general provision operating here.
But for the same land, you cannot have both the benefits, because either you classify the land as non-agricultural,
yes,
or you classify as building with structure.
Now, my lord, there are vacant lands and there are buildings with structures. Now, the buildings with structures,
these were not segregated, not demarcated.
The land,
it was a total land.
The composite whole. But in that composite whole, the non-agricultural land in my khas possession would be non-agricultural land of which I am possessed. The structures which are there have a land appertinent there too. So
you say the vacant land is non-agricultural land?
And the structures which are there are land appertinent there. All right. So, my lord, this was, my lord, the premise on which, my lord, we had attacked the resumption of 1.96. I'll show you, lordship, my lord, the orders. Now, my lord, once, my lord, 1.96, my lord, the Honorable Division Bench held that the retention, resumption, and notice of delivery back of possession of 1.96 were bad, because 6.3 could not have come in respect of that 1.96 acres of land. But regarding the 14.33 acres, the division bench did not have the occasion to say much, only said that as far as the 14.33 acres are concerned, it is nobody's case that that point of time, it was not being used as a factory. Now, my lord, after that judgment of the division bench is concerned regarding 1.96 acres, there are separate proceedings, but we need not dwell on that. Regarding 14.33 acres, we had applied under 4C for conversion of the nature of use.
This is now below the ceiling.
This is below the ceiling.
But your total holding at the time of, we have to see the point of vesting. At that point of time, you cannot now say that this is beyond the below the ceiling or that is beyond the ceiling. It was a total
Yes, that is, so that's the fictional date. On the fictional date, according to the calculations available,
see the date of vesting.
Yes, that's the date of
14.33 and 1.96 were together, one part of one land.
So there's a land building combined.
Now you cannot say that this has come down under the ceiling limit.
No, by that minus 1.96, no, never. That's not my submission. It can't be. The fiction operates on the date of vesting.
Milord,
On the date of
may I intervene, Milord?
Yes, Mr.
Out of 14 acres, the area covered with structure is separated. This will not come under land, non-agricultural land. That will come under the category land with buildings and structures. The rest will be about 11 acres. Kindly remember this. Out of 14 acres, the area covered with land and structures will come under a different category of Section 6. We have filed a supplementary affidavit indicating that 4 acres was covered with structures. Factory was running there.
So, Mr. Mukherjee, if you take the date of vesting, then this 14.33 plus 1.96 had to be taken. Even
not
if you,
together, not together, separately.
Why do you say that it was your total land which is to be considered as a ceiling limit for the purpose of Section 6?
Not total land, Milord. The different categories come under different ceilings.
1.96 was vacant.
Non-agricultural land means non-agricultural bare land.
But your total land on the date of vesting, Mr. Mukherjee,
15
under the
acres.
Estate Acquisition Act was 15 acres.
Yes,
I
yes.
mean 14.33 plus 1.96, whatever that comes to. So out of that, you say even if we take that total, then also 11 acres was vacant land. So insofar as the vacant land is concerned, that was pure non-agricultural land. So you are entitled to retain under C.
Within the ceiling, within the ceiling.
Within the ceiling. Very, very.
And land with structures will come under a different category.
Now, the other question, Mr. Mukherjee, which comes up in our mind, we want a clarification from you, that can you segregate, because the property was not demarcated as such. So 11 acres was vacant and 4 point something was structure. So doesn't the entire land come within the definition of land with structure? 11
No.
plus,
No.
not that.
So kindly look at Section 6.
Yes.
Land with structures, no ceiling. And
land comprised in or appertaining to buildings and structures.
Sub-adjacent land.
Very well. Very well.
And appurtenant land.
So not exactly, the language used is not land with structure at all. I mean land comprised in or appertaining to buildings and structures.
Yes.
Very well. Get your point. Understood. Very well. Yes, Mr. All right.
And that's how we claim the property to be under the ceiling.
Yes.
This we have put, Milord, in the
That is
form
not
of-
disputed. That is not disputed, but they're saying.
So that was about of about 4 acres something, that B, and C was the rest, non-agricultural. Very well.
Now, Milord, when we went and we applied before the first forum, that's the DL and LRO, the first forum, and in fact, the other two fora also went on the one basic premise, which according to us is inapplicable. They said as follows: your land under 14.33 acres is covered by a 6-3 order of the government. If you are covered by an order under 6-3 of the government, then by subsequent amendment to Section 4B2 of the Land Reforms Act, you are deemed to be holding that land as a deemed lessee under the government. 4B2. Please have a look at me, Lord. 4B.
Please.
পেয়ে গেছি তারা। This was incorporated into the statute book in 2017. Please have a look at 4B2.
Yes, yes.
Notwithstanding anything contained.
Right.
in this act or in any other law for the time being in force, the widest possible, my lord, non-obstante.
Yes.
So the widest possible non-obstante, my lord, 4B2, notwithstanding anything contained in this act or in any other law for the time being in force, or in any agreement, custom, or usage, or in any decree, judgment, decision, or award of any court, tribunal, or authority, where an intermediary has been allowed to retain land irrespective of area and classification, and with or without any order under clause G of subsection 1, read with subsection 3 of section 6 of the West Bengal Estates Acquisition Act 1953, or where such retainer has already transferred such land or any part thereof to any person or institution or company who is in possession of such land or part thereof by an instrument mentioned in subsection 1 of section 5 of this act, such retainer or transferee, as the case may be, in our case that's inapplicable, shall be deemed to hold such land or part thereof as lessee directly under the state government with effect from the date of vesting under the West Bengal Estates Acquisition Act 1953, or from the date of such transfer as the case may be, for any of the purposes as referred to in the first proviso to section 14Y, excluding tea garden, in accordance with such terms and conditions as may be prescribed. There's also a simultaneous amendment to the rules where Milord, the terms and conditions, Milord.
6.3 according to you was a surplusage. Surplusage, 6.3.
So our argument is simple. 6.3 was the point is so self-evident, it has already traveled, Milord. 6.3 is a surplusage. 1AB, 1AC covers me. If it covers me, then in Ratnagiri paragraph 10, the Supreme Court has held that this is automatic retention.
Cite that.
Yes.
Before proceeding, let us go point by point.
Yes. So, Milord, 6.1A to 6.1E, it is automatic. There is no requirement of any specific order being given, if it is within that limit. Paragraph 10. Calcutta. This was on the point, yes. A perusal of section 6 of the 53 Act discloses that there is a difference between clauses A to E of section 6.1 on the one hand and clauses F and G of section 6.1 on the other. While in case of lands which can be retained under clauses A to E of section 6.1, the retention is automatic from the date of vesting and no order of any authority need be passed for that purpose. In the case of clauses F and G of section 6.1, these are married to 6.3, F and G. The retention after the date of vesting is not automatic, but it is only when the state government passes an order under section 6.3 of the 53 Act. In other words, after the date of vesting, the lands mentioned in clauses F and G of 6.1 cannot be retained by the intermediary unless and until an order is passed by the state government under section 6.3 of the 53 Act. Also, unlike lands mentioned which can be retained after the date of vesting, irrespective of the area. In case of lands mentioned in FNG, only so much as the opinion of the state government may require. So, auto retention, irrespective of area, in cases where no area is.
At that point of time, we had a running factory, had a running industry there.
Had a running industry on 14.33, not on 1.96. On 1.96, I didn't have. That's been held by the division bench. And in any way, if my lord sees the mathematics here, my lord, is like Urban Land Ceiling Act. There's no special general between A, B, C, D. So if lands comprised in buildings, that is the sub-adjacent land, it's a separate category of retention. And sub-adjacent plus non-agricultural, we are out. But we are within C. So there's no need for 6.3. Now, could we have taken this point? Yes, we could have. There are judgments I'll cite before your lordship, Lord, that here there's a case of no estoppel against statute because I don't get any benefit. I would have.
Would you have taken this point where?
Now, after having countenanced the 6.3 order initially, would it be unconscionable? The answer is it would not. And the estoppel against statute formula would work here simply because by taking this, we have not taken any benefit of land which would otherwise have been beyond the ceiling limit, but has been.
All the retention is automatic under 6.1b, A2 those before G. Now, but still you have to file a form, you have to disclose which part of the property.
No, nothing is required.
Not in under Estate Acquisition Act, it is not required.
Kindly look at the rules of the Estate Acquisition Act. It's not necessary.
We would like to be clear on that also.
Kindly have a look at rules.
এসে একটা রুলসটা কোথাও আছে দেখো ল্যান্ড ম্যানুয়াল বা কোথাও
আমি না
ম্যানুয়ালটা আছে কারণটা উপরটাই ওটা দাও
রুলটা দেন
হ্যাঁ দাঁড়ান স্যার
ম্যানুয়ালটা একবার দাও না উপরে ওটাই এটাতে কোথাও আছে না ম্যানুয়ালের সঙ্গে দিলে ওরা দিল
আলাদা করে ওটা হাতের সামনে নেই
এই যে এইটা
For A, not rule 4A.
Yes, we are looking at actually 4A.
Proviso, first proviso.
Yes, Mr. Mukherjee. That applies to C and D.
Yes.
So your land comes C and D.
Yes.
And your land comes under C. So therefore, well.
4A, my lord, has seen the 4A of the Estate Acquisition Rules 1954.
4A, yes.
4A proviso. So the first authority said that by virtue of This 6.3 being there, you go into the 4B2 pathway, whether you like it or not. Therefore, you are a deemed lessee under the state. Go and approach the state government for a lease, and in that lease, get your conditions done. You can't apply under 4C. The second authority was the appellate authority commissioner. The appellate authority sent a group of persons to inspect the premises. They came back and found that there was a frugal factory in operation, because there were a number of people who were employed, 45 odd employees, etc. The appellate authority said, because there is, you say, a factory in operation in 14.33, you have to take steps for the purpose of getting the factory closed first. How can I grant you permission under 4C? That's a begging question. From that, we went to the West Bengal Land Reforms and Tenancy Tribunal. The West Bengal Land Reforms and Tenancy Tribunal again came back on the 6.3 point. Since you are 6.3, you are siphoned off to 4B.
6.3 is the strongest point against you.
Strongest point against me. They said you are siphoned off to 4B. Once again,
their case is that once you take advantage of 6.3, you cannot resile from that position and say it was not 6.3.
And our case is that we have not taken advantage of 6.3.
No, your case is that 6.3, even if we took advantage of 6.3, that was a surplusage, since we were in any event entitled automatically to retain this under
6.1
C, because C gets the advantage of Mr. Mukherjee pointed out 4A, that proviso also. Yes. Therefore, for that automatic retention, non-agricultural land under 6.1C, you don't require to do anything whatsoever. You just sit tight. You don't require to give an option as mandated under 6.4B.
And there are judgments also, my lord, that in case I have not exercised an option, the automatic retention doesn't go away. Yes. There are judgments on that. The automatic
cite 1 or 2 on those also, but
yes,
that is very obvious, axiomatic. But still cite at least one judgment on that.
Yes, I'll
don't cite
not
all
too many
the judgments you have found.
No, there that was for that purpose, because I wanted to make a point.
Kindly turn to section 6.5 of
Yes.
the state resolution. 6.5.
6.5.
No judgment is required.
No. This is, yes, obviously there.
If I don't file any return, they will allow me to retain up to the ceiling.
So within ceiling,
it is there on us, even if you don't file. Yes, we have judgments on this. Our court also has passed judgments on this. But Mr. Mukherjee, here you created the problem by taking advantage of that 6.3. That is what is, what went against you.
My lord, 6.3 was inapplicable patently. Cannot defeat my right under the provisions of State Resolution Act. No advantage I have taken.
Very well, Mr.
The other question is, previous idea was that wherever there is a factory and the factory land is allowed to be retained, it will come under 6 and 6.3. Later development of the law is that if the land is held within the ceiling and there is a factory, there is no question of 6.3.
Right.
Darjeeling properties Supreme Court has held so.
Mr. Mukherjee, the site is, please give the name again. We are not like you. So you have to understand the distinction also. Not only on the law, but also on the persons hearing you. Mr. Mukherjee, just give the name again, please. Give the name of the judgment again. Jain Properties, or what did you say?
Calcutta Minerals.
Calcutta Minerals.
Calcutta Minerals.
Can you please give the citation to us?
Yes. 2015 8 Supreme Court cases.
Yes.
655.
Thank you.
The relevant paragraph is at the end, paragraph
40, sir.
Paragraph 40. এই জাজমেন্টের কপিটা দিলে?
দিয়েছি স্যার।
In this connection, my lord, kindly recall
Yes.
the provision of Article 300A.
Yes. Can we definitely
Person can be deprived only under the authority of law,
authority of law? Yes.
not under any estoppel and things like that.
No, no. Thank you, Mr. Mukherjee.
অভিজিতের মধ্যে
Yes.
আরেকটা আছে, অভিজিতের মধ্যে দেখ কোনটা বল?
Yes, Mr. Banerjee, anything else?
Yes. Now, my lord, there are while on this, my lord, there are just one or two other judgments which your lordship may be pleased to consider. One of them, my lord, is Juhi Finley's Private Limited versus State of West Bengal, 2017, Volume 3, Calcutta High Court Notes, page 97.
SLP was dismissed.
This was the Calcutta judgment.
The Calcutta division bench.
Para, Mr. Banerjee.
Yes, yes. You প্যারাটা বলতো।
Proposition, Mr. Banerjee?
Proposition is that it is with if it is within ceiling,
the 60 does not.
Yes, 38 onwards, my lord. Or para 34 onwards, 34 to 40 onwards, 40, 41, 42. Para 40.
Your factory was not operating on that date.
Yes,
it was operating.
It was operating. On the 14.33, it was operating. The fine print is that they are these two are separate categories. That is automatic, and once that goes, the automatic thing gives me the cover I need. Then the question would only one question would arise, being the devil's advocate, is why then 6.3 at all?
40 does not help you. 40 says if factory related activity was not carried on, then.
But the scheme is mentioned below 37, 38, 39.
This judgment is primarily on if it was closed long before and all. Para 55, 40, not directly on the point.
Yes, but it discusses, my lord, two other judgments, BRC construction. What's BRC
Calcutta Mineral
construction?
Supply is directly on the point.
Yes, and
Not
para
really often.
47, if your lordship sees of this report, it deals on, it deals with, my lord, BRC construction. And BRC construction also, my lord, spoke of retention, my lord, being available under the other provisions. But that is directly on the point, the one which I gave the Supreme Court. কোন প্যারাটা দেখাতে পারি দেখানো দরকার আছে কিনা অভিজিৎ
You should have cited BRC construction, not
BRC.
this.
I'm sorry. BRC.
Have BRC, then please cite that.
Yes, yes, I'm sorry.
That is more relevant.
Very well.
Para 57, 58 of that.
Yes.
As Mr. Mukherjee is arguing,
Yes.
300A
300A
angle is also there.
57, 50. দেখা
Yes.
বলো না No, there have. I will not multiply judges.
No, no, no. This is sufficient.
My lord, just, my lord, they say that while challenging orders, the orders should be placed once before the courts.
Do it.
Just, my lord.
No, you asked for that also.
Yes, yes. The three orders.
First, we wanted to conclude.
Yes, yes, yes. The three orders, my lord, for your lordship. Prothom order.
Just start with the tribunal. Directly.
I wanted
has
to,
merged with the tribunal.
they are basically shortish orders. We can just skip over and
No, whatever you want. You
yes,
can
so, my lord,
this
just
all
see 148 just once. It'll take 3.5 seconds.
whichever way. But 3.5 seconds you have to hire Mr. Ratnakar.
No, he's quicker. He's 1.5 seconds. Before I can open my book, his point is over.
148. He's a rapper barrister.
He's a rapper barrister. And in conferences, he's even faster.
Oh, good. Yes. We hope he was here because we don't want to speak behind his back.
No, but we are
We must convey to him as a.
Yeah, we are praising him. Not only rap is a skill,
So let us come to this. Yes.
14th October 2020, page 150.
158.
150. That's where the final order starts. This is a record of proceedings. Annexure starts at page 148. Notice issue taken up for etc. The final order is page 150. 14th October 2020. Page 154 is where our submissions are taken note of, and that's where he deals with it.
Very good. Next judgment, Mr. Manager.
Next is page 250, the commissioner, the appellate forum. 252 is the reasoning from the middle of the page, heard both parties. Two five two middle.
This is absurd.
Yes, yes. It begs the question.
Yes. Let's come to tribunal.
Now,
252 last line onwards. Seen it.
now, my lord, volume 2, page 356. P58. Questions formulated. Middle of the page. P60, my lord, we have no hesitation to hold fourth paragraph.
The premise of all these authorities, first and third authority, is that if it is covered by a section 60 scenario and you took retention under that provision, if the order was passed under that, then you are covered by that and that alone. You cannot go back and take advantage of 6(1) CD, BC. Now, C. So it would be, but the apparently the proposition of law as settled by the Supreme Court is, and what you are arguing is also, that even if it is squarely covered by section 6(3) scenario, something was running there and it was also required for that purpose and you took for that purpose, then also by virtue of 6(1)(c), we were in any event entitled automatically. So therefore, what I'm entitled to automatically,
I need not be
I
given
need
again.
not be,
I need not be given again.
Need not be given a benefit, and that benefit was a superfluity.
Superfluity.
The case is closed and hearing is concluded. Then, Mr. Mukherjee, your concluding hearing.
Grateful Lordship.
None appears for the respondent stroke state authorities. We note that although the state had been consistently appearing previously, on the last occasion when the matter was called on for hearing in regular course, that is on January 13, 2026, the state remained unrepresented. Even today, the matter was appearing in the list, and but at the time of call, the state chooses to remain unrepresented. Accordingly, we had no other option but to hear the petitioner and close arguments. Hearing is concluded. The matter is reserved for judgment.
Obligement.
Thank you. এই বইগুলো শুদ্ধ পাঠিয়ে দেবেন তো। এই বইগুলো এগুলো পল্লবকে দিয়ে ওই যা করেন তাই করে দেবেন। হ্যাঁ, বইগুলো তাহলে অন্য ম্যাটারে লাগতে পারে, কিন্তু যেন ওইটার সঙ্গে দিয়ে দেয়, যখন যাবে যেন ওটার সঙ্গে 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 দিয়ে দেয়। নেক্সট ম্যাটারে।
Item number 2.
With the Lordship's leave.
Yes, please. হ্যাঁ, হয়েছে, যেগুলো হয়েছে সেগুলো ডিসকাস করুন। This is the second consecutive occasion when none appears for the parties at the time of call. Accordingly, at the accent. Accordingly, CR 679 of 1988 is discharged with appeal connection. শুধু সিআরটা কেন আসছে, অ্যাপিলটা কেন ব্র্যাকেটে নেই? শুধু রুলটা আলাদা করে দিয়েছেন কেন? অ্যাপিলের রুল হয়তো ওই রুল তো ইন্টারিম অর্ডার ইস্যু হয়েছে, ইন্টারিম অ্যাপ্লিকেশন ইস্যু হতো। রুল অ্যাপিলে ইস্যু হয় না, ইন্টারিম অর্ডারে। হ্যাঁ, কিন্তু আমি যদি এটা রুলটা ডিসচার্জ করি তাহলে অ্যাপ্লিকেশনটা অ্যাপিলটা তো পেন্ডিং থেকে যাবে। অ্যাপিলটা লিস্ট করে দেবেন, রুলটা ডিসচার্জ করে দিচ্ছি। সেম অর্ডার, সেম যেটা আগে অর্ডার আছে, সেম অর্ডার। এটাতে অ্যাপিলটা দিয়ে দেন পরে। রুলটা থেকে যাবে 21 অর্ডার থাকলে মুখে বলে দেন সেম অর্ডার। এগুলো সবই বোধহয় তাই নাকি? শুনুন, সেম অর্ডার না থাকলে যদি আগের অর্ডার না থাকে তখন বলবেন সেম অর্ডার হতে যাবে। সেম অর্ডার, সেম সেম সেম। দাঁড়ান, 10টা আগে হোক, ফাইলটা বার করুন, চোখে দেখি। আপনি দীপঙ্করকে দিন, আমি দেখে নেবো। 10 বার করে ফাইলটা দিন, এক এক করে সব আমাকে না, দীপঙ্করকে দিন, আমি দেখে নিচ্ছি এখান থেকে। সেম অর্ডার, সেম অর্ডার। আপনি দিন না ওকে, আমি দেখে নেবো। 11 ডেকেছেন, দিন ফাইলটা। সেম অর্ডার, সেম সেম। ওরম করতে হবে না, আমি দেখে নেবো। সেম সেম অর্ডার, সেম অর্ডার, সেম অর্ডার, সেম 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 অর্ডার, সেম অর্ডার।
22, my
সেম
lord.
অর্ডার।
No, my lord. My lord,
My
my lord,
Yes.
I appear for the appellant lordship. I'll be candid, my lord.
Don't be candid, move the matter.
My lord, it has
No
just been,
candid is necessary, move the matter.
my lord, it has just been briefed to me, my lord.
No, don't take
sometime-
such briefs, please.
My lord, sometime, only one
Never
day's
say before a
time.
court, just been briefed. If you are just briefed, we were briefed on the. If I take the brief on the corridor, ma'am, I have to prepare myself on the corridor.
My lord,
Otherwise, I don't take the brief. I don't take the brief. If I am briefed before recess, a matter is being heard, a judge is very rude to the junior and is trying to impose a cost like us. If I am briefed before recess, I get ready during recess and I face the judge after recess. We never say before a judge, I have received the brief. It's your problem. It's absolutely your problem. If you can't get ready in a matter within half an hour, don't take a brief.
my lord,
I got a brief yesterday. It's your problem. Why should the litigant suffer for that? What is the application for?
my lord,
Why
for
did you
stay.
take the brief? Move the matter.
My lord, for stay, and my lord, another application is required to be taken out under order 41 rule 27 to bring certain documents
When
on
you take
record.
out that application, we'll think about that. But what is the ground in the appeal? What have we challenged here?
Yes, my lord. My lord, the premises in question with respect
What
to
is the infant decree?
Yes, my lord.
Recovery of person.
Yes, my lord. I was for the defendant in the suit, lordship.
What is
My lord, a decree has been passed against me for eviction, lordship, and for recovery of possession.
so adversity brings out the best out of you.
My lord. No, my lord.
Yes.
Lordship.
Eviction decree on the on what ground?
On my lord, the point that I had taken was that it is a thicker property, and
So they filed the suit on the
they
ground that
filed
you were a.
I am an unauthorized occupant of the premises.
You say you are a ticket.
I am saying that I'm a Thika tenant and proceedings are pending before the Thika
What proof did
tribunal.
you produce before the court?
My lord, those proofs, that is the main thing, my
Nothing.
lord. No, there was an inspection notice which was brought on record by way of an exhibit, but that was not considered on the ground that the holding number did not match with the suit premises number. But later on, lordship, we tried to bring on record.
If you have not filed that order for rule 27, why was the appeal mentioned? Because that will be the premise of your appeal.
My lord,
Learned counsel it goes out of the list. Learned counsel for the appellant seeks some time to file an application under order for rule 27 of the Code of Civil Procedure. You are not enjoying any stay here.
No, my lord. This is the first time the matter
Order
is
41
taken.
rule 27 of the Code of Civil Procedure. Full stop. Accordingly, let the matter go out of the list with liberty to the appellant to mention the matter afresh as and mention the matter afresh for inclusion in the list as and when such application is filed.
Deeply obliged,
Upon
my lord.
upon service of an advance copy to the learned advocate for the response.
My lord, deeply obliged, my lord.
Next. Give your appearance. ও disappearance দিয়ে চলে যাচ্ছে. Only your appearance. Yes.
The next matter that I appear for the appellant.
Yes. Right.
This is my lord. I have filed an application for injunction. My lord, lordships have admit the appeal. My lord, directed for preparation of paperwork, my lord, as well as stay of the degree. My lord, this is a suit. My lord,
You filed another injunction application after
injunction application.
Acha, the suit was for specific performance.
Performance of contract.
They got a decree.
Lord,
Yours should
plaintiff, I am the plaintiff, suit dismissed.
injunction.
No,
In a trial court, did you get an
In
injunction?
trial court, I have got an order of injunction which I have annexed.
This
in
is which can
and
two.
2 of 2025.
Have you annexed that?
I have annexed which is appearing at page 11. Page 11 is the, Lord, the ad interim order.
You are the proposed purchaser. You
I'm the
wanted to
intending
purchase.
purchaser.
Yes, what do you say to the injunction?
Manoj, first of all, Manoj, the last order passed by your lordship is on Manoj 24th of April 2025. By Manoj, which they have Manoj, on their prayer, your lordship stayed the part of the decree by which Manoj I have been directed to Manoj, by which Manoj I have the suit was partly decreed. I have been directed to pay the amount which they have paid. So on their prayer, your lordship have stayed it. Now, Manoj, almost
This is the injunction separate.
Manoj, on almost 1 year is over. But Manoj, they have not taken any steps for hearing of the appeal. Manoj, if they have Manoj do not take any
notice of appeal, they have put in requisites and it has already been issued. Service return has been received.
Yes, Manoj, but they have not taken any steps.
Both the notices received by the respondent number 1. So they have taken steps.
Manoj,
what other steps should they take?
Manoj, they should have taken steps for preparation of paper book. No paper book has been served upon us.
Have the trial court records come? Neither the trial court's record nor any communication. Already trial court records were communicated. I mean, special messenger cost was deposited by them.
Yes.
That's the office report. Through a special messenger, it was called for. Till date, the trial court records have not arrived.
And Manoj,
so it's not their fault. We'll continue.
Manoj, and one another thing, Manoj, eviction suit was pending against them because Manoj, they were my tenant. So Manoj, an eviction suit was pending, and Manoj, it is my instruction that they have not complied with 7.1 and 7.2. So Manoj, the consequences will follow. Now they are Manoj paying Manoj injunction for Manoj not disturbing their possession. Manoj, this will now Manoj affect my suit.
There was an eviction suit. Lord, I filed an application under 151 for stay of the Lord, eviction suit. Lord, my stay application was rejected.
But till you get a decree, you are a tenant. They are entitled.
Lord, I moved before the Honorable Lord, the High Court. Lord, the High Court has granted Lord stay of the eviction suit.
File your short affidavit in opposition to
yes,
this. And we want a disclosure of everything. And you also file in.
Yes,
we'll record your submission. We'll grant injunction for the time being. But we'll permit you to file an affidavit and disclose all those documents. The present appeal arises out of the dismissal of a suit for specific performance filed by the plaintiff stroke appellants. Push up next para. Learned counsel for the appellants, by placing reliance on the annexures to the present application, submits that during pendency of the suit, and the plaintiffs were enjoying injunction restraining the defendants stroke respondents and their men and agents from creating any third party interest over the suit flat and from alienating the suit flat and maintaining status quo over the suit flat in respect of possession of the plaintiffs. Push up next para. Learned counsel appearing for the respondent submits that an independent eviction suit is pending against the appellants in the said suit, in view of failure of the plaintiffs stroke appellants herein to deposit the to make the deposits as contemplated under sections 7 within bracket 1 and 7 within bracket 2 of the West Bengal Premises Tenancy Act 1997, the suit is about to proceed ex parte. Next para. Learned counsel for the plaintiff submits that the plaintiff stroke appellants herein had taken out an application under section 151 of the Code of Civil Procedure for stay of such suit, which, being dismissed, a challenge was preferred before this court, and at present, in connection with the said challenge, there is a subsisting stay order in respect of the eviction suit. Be that as it may, in order to get a complete picture of the factual background, the respondents are directed to file their affidavit in opposition to Can 2 of 2025 within a fortnight from date. Reply, would you like to file it earlier?
Plus 2 weeks will sufficient.
Very well. Within a fortnight from date. Reply, if any, shall be filed within a week thereafter. The application shall next be listed on February 17, 2026. Next para. The respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, encumbering, and or creating any third-party interest, and or from disturbing the peaceful possession and enjoyment of the plaintiffs in respect of the suit property till disposal of the application. Right. Right.
Number 24.
For the appellant, my lord.
Led by Mr. Chittapriya Ghosh, my lord.
Yes.
Opposite party, respondent number 1 to 3, my lord.
Really.
Lord, this appeal arises.
Reply.
Oh, push reply.
We are wanting or not giving. On the last occasion, you were directed. Have you given a copy to them?
Yes.
No, my lord, kindly, we have not received any
Reply
copy.
thou?
Reply.
Yes. Say so.
Enclosures with final application. Evident reply.
Have the signature identified from your learned friend.
The clerk near you.
We hope Mr. Ghosh has not taken it.
We have not find in our brief.
You are enjoying an interim order.
No, my lord. This appeal arises out of a my lord allowing an order of injunction application, my lord, in contested form. I'll give her a copy.
Give a copy. Let her come back tomorrow. Let her go through the reply because the reply it's thickish. So there must be something.
These are, my lord, all admitted documents, my lord, of all.
He doesn't even know whether those documents are admitted or not.
No. All trial court process certified copy.
He does not know. She has to move the matter.
Copy আছে তো?
হ্যাঁ, you can start moving the matter.
I'm giving her a copy right now.
Go through that.
Yes, my lord.
Without this, can we hear the matter?
Milord, these are all Milord records of trial court.
What is the case about?
Milord, what happened, Milord? My client is the defendant number 3 and 4, Milord, in the partition suit. Now, Milord, this application for injunction has been disposed of, Milord, on contested form, Milord, allowing Milord the granting order of injunction, Milord, till disposal of the suit. Milord, I am aggrieved by that because my first point would be even the facts have been incorrectly recorded in the impugned order.
Incorrect recording of facts. Does it have a German bearing on the?
Yes, definitely.
How? Tell us what
definitely. Because, Milord, he says that the record of rights, RS record of rights in view of the intermediary has not been, Milord, produced in the record at all. Milord, that is, Milord, Order 7, Rule 14 compliance in our written statement that is there. Milord, the main.
We don't understand.
Milord, if a lordship.
What would the RS record show?
Yes, RS record will show that, Milord, they have, Milord, there is a complete loss of title of the plaintiff.
By virtue of title deed?
Exactly. Kindly, Milord, see your lordship's, Milord, order dated 6th of February 2025. Order.
You have annexed those documents to the reply.
Exactly.
No. Stay application.
In the stay application, those are annexed.
And what have you annexed in the
reply? Milord, a certified copy of the order sheets in the trial court, and one supplementary affidavit to the Milord injunction application.
To show what? What will be
in the written
why the order sheet?
Yes, Milord, to show, Milord, in the affidavit in opposition, my learned friend had made a categorical statement: the original deed of partition or any copy thereof has ever been served upon the trial court, and as such they could not challenge the same. Milord, the supplementary copy of the supplementary affidavit has been annexed, which shows it has been, Milord, served upon them, and Milord, there is Milord, the order sheets have that's why, Milord, certified copy of the order sheets with records, copy served to other side.
This execution of Mukaradi Mourasi part-time document has been
exactly.
That is annexed to the stay application.
Stay application, which was also part of
stay application. You must have a copy of the stay application.
Yes, my lord.
Milord, neither of the parties cannot go beyond the pleadings of the trial court in a contested.
Hear this application. Hey, you'll get 7-8 minutes. We'll come back and we'll take up this. Yes.
My lord, kindly see, my lord, the impugned judgment. My lord has gone to, my lord, 6th February, my lord. February.
6th February. Impugned judgment?
Ache.
He was roaming about with it.
It says in code number 551.
No, the reply copy?
Yes, I have the copy.
Yes. The impugned judgment of.
Yes, impugned judgment.
Oh, this is a misapprehension. Sorry, the order. Yes.
Kindly, my lord, kindly see, my lord, I'll be placing, my lord, its entirety, but kindly see, my lord, the decision with reasons at the, my lord, last 2 pages.
Yes.
Kindly see, my lord, let me place first this part. Kindly see, upon hearing the argument of learned advocates and after having gone through the materials on record, this court comes to hold that admittedly there was no denial of the fact the predecessor of the plaintiffs were the co-sharers of land in RS plot number 417. At the time of hearing, the defendants have come out with one registered deed of partition being 465 of the year 1942, claiming that predecessor in interest of the plaintiff had partitioned the land of the suit plot number 417 and also sold it to one Kinuram Khan. My lord, completely, my lord, the wrong recording. There was no sale in favor of Kinuram Khan. Kinuram Khan, and that is challenged by the plaintiff as fake, forged deed. My lord, this is also complete erroneous recording.
How did it come about? Kinuram Khan, where did he come
Yes, Kinuram Khan, my lord, what happened, my lord? There was a deed of partition. There were 7 my lord, branches of that deed of partition. My lord, one was Bonkim's my lord heirs, and another was my lord Jyotish and Kshitish's heirs, and where we come from, Nirmal and Sharot. Now, my lord, what happened? This Bonkim's share and the Jyotish demarcated. I will show that. And Jyotish's share, my lord, they have, my lord, executed 2 my lord Mokarari Mauroshi Patta, my lord, in favor of my lord Kinuram Khan. Now, my lord, therefore, that was not a sale. Now, my lord, my first point would be, my lord, after Estate Acquisition Act, my lord, the intermediary right, my lord, had got vested.
When was those executed?
42.
Then prior to that.
Prior to that. They may be, my lord,
Mauroshi Mokarari Patta is of a different footing.
But, my lord, after, my lord, Estate Acquisition Act, even if, my lord, Kinuram was, my lord, in possession by way of the document, my lord, had vested. Therefore, Bonkim and Jyotish Kshitish's, their, my lord, right had completely. Therefore, my lord, the plaintiff's, my lord, side has, my lord, the title of the plaintiff, my lord, there is a complete loss of
What
title.
about your title?
Yes. Now, my lord, we did not do that. My lord, thereafter, there has been many subsequent sale. Our title were even recorded, my lord, in RS record. Our names were even recorded.
The land was not vested?
No.
Under the Estate Acquisition Act?
We did not execute, my lord, any deed.
Very well.
Now, my lord, kindly see, and that is challenged by plaintiffs as fake and forged deed. My lord, we disclosed, my lord, this deed of 1942 when we filed written statement and written objection, my lord, in the year 2016. Till date, my lord, there is no amendment of plaint, my lord, challenging that. In the written objection, my lord, to the injunction in the counter affidavit to the written objection, means affidavit in reply to our written objection to the injunction application, they have only one, my lord, made a stray statement, this is a fake deed and there was no existence of Kinuram Khan. As of today, the plaint has not been amended. Section article
produce the partition deed and the Mauroshi Mokarari Pattas as well.
Yes.
Yes, then let us proceed.
And in support of their case, the plaintiffs have filed certified copy of RS Khotiar number 159, photocopy of RS Khotiar number 153/1. Here is also, my lord, incomplete recording.
Right.
My lord, here, my lord, we have produced 153/2, 153/2, 3. Court, my lord, completely missed that out.
How would that help you?
Milord, in those Milord, the Kinuram Khan's name Milord has been recorded as Raj. Milord, Bonkim and Shotish Khitish Jyotish, their names are not there. In information slip in respect of RS plot number 417, where from prima facie it appears that Bonkim Chandra Sapui, Shotish Chandra Sapui, and Jyotish Chandra Sapui and Khitish Chandra Sapui are the riots in respect of RS plot number 416, 417, 418 and 418 and 420 to the extent as mentioned therein. Since the RS record of right as produced came into operation after come into force of West Bengal Estate Acquisition Act 1954, since RS record of right do contain the names of predecessors and plaintiffs, since the submission of the learned advocate of the plaintiffs that no record of right is still be prepared in the name of Kinuram Khan, even after the alleged partition deed of 465 of the year 1942, since both the parties are claiming their right over the suit property based on respective documents, since an order of status quo over the suit property has to be maintained, otherwise there will be multiplicity of proceedings and apprehension of the change and character of the suit property, and ultimately Milord.
So, Bhattacharya, then the fact remains that as per the partition deed, their predecessor had some title. Now, therefore, your case relies on Mukarari Patna, Morris Mukarari Patna. But trial court says there's a tribal issue, not in so many words, tribal issue arguably is because RS records were prepared after this and it reflects their names. So why is it not? Why do you say a tribal issue has not been made out? This is for the grant of injunction.
So,
they
Milord,
don't have to prove
there is also Milord an admitted document, Milord, where they admit Milord
partition deed by itself does not help you because that shows that their predecessor also got some part.
No, Chinnito, we say their Chinnito partition was done. Milord,
that was in respect of a part of this property.
Entire Milord suit property is 162 Milord bighas. Out of that, Milord,
this partition deed was regarding that 162 bighas,
along with many other properties. Milord, we are concerned with only 6 schedule of the Milord partition deed.
6 schedule, why?
Because Milord,
you were allotted through 6 schedule.
Now, Milord, kindly, if your lordship, Milord, kindly comes to Milord, there is Milord.
So therefore, you say as far as 6 schedule is concerned, there is no. It's a part demarcated
property.
It's not joint at
exactly. Now, Milord, if your lordship would kind enough to come to Can 2.
What is Can 2?
Milord, this is my lord on the Milord in the order dated 6th February. Milord, kindly see. Milord, I have relied upon Milord a deed.
Did we pass directions regarding Can 2? It will be heard along with the appeal.
No,
not yet.
This is but this document, Milord.
You got a copy of Can 2?
Yes. Milord, however, Milord, kindly, if your lordship kindly comes to page 14, there is a deed of 2011. Kindly see Kovala Data Sanjeev Sapui.
Thank you. Number 1 thing.
Sukumar Sapui is the data.
Yes.
Sukumar is who? Who's predecessor?
Father of Sanjeev Sapui.
Plaintiff number 1.
Sanjeev Sapui is the plaintiff number 1.
He has died. Hina Nashkar is number 1 now.
No.
Appellant number 1.
Hina.
Oh, sorry. They're the other side.
There. Now, Milord, kindly, Milord, this document is also Milord annexed, Milord, in my stay application, but this was not part of the trial court records. That's why, to be on the Milord safe side, we have filed.
How does this help you?
Exactly. Kindly comes to Milord.
Sanjeev got some property.
Page 2 of that deed.
Yes.
Kindly see, Milord, the last paragraph of that page. Otopor Ukto Jyotish Chandra Sapui. On the last line, Milord, they admit Sampadon Koriachilan 23rd May.
They have not relied on this document?
They have not relied upon. Milord, we got this. That is my explanation in Order 41 Rule 27 application. Upon searching, Milord, there are many properties of these Sapuis. Milord, after getting Milord hold of Milord searching this document, we came. This is annexed to our stay application, but not part of the trial court records. Then that's why Can 2.
Here that is admitted. That part.
Exactly. Now, Milord, another thing.
No, if the partition deed stands, then
Chinnito. চিহ্নিত
What is the partition deed?
exactly
Page 85. Of the stay application.
page 85 এখান থেকে দেখো এখান থেকে দেখো kindly Millard it starts from Millard page 66 of stay petition annexure E. But every page Millard has a type copy Millard the next page
66
of the stay petition Millard stay application can one
what
can one
this covers the entire suit property plus more,
plus many more.
but the entire suit property is covered.
Kindly see Millard প্রথম পক্ষ is
Their father was a party.
no
Was a party. Their predecessor.
their predecessor. Kindly see Millard
How are you related to them? You are to a different branch of this
different
partition.
branch. Yes, that's what I want to show to your lordship. Kindly comes to
So
me.
his right is exclusive regarding at best regarding his father's portion, unless that the Morishu part of that part is.
Kindly see Millard the page 66. Kindly see page 67. প্রথম পক্ষ is প্রাণকৃষ্ণ. Second is Upendranath Shapui. Third is Bonkim Chandra Shapui, which Millard will be relevant. Third is relevant. Then Choturtho is Dhirendranath. We are not Millard. Then Panchami Shoshi Bhushan. Shashto is will be relevant. Millard. The Shotish, Jyotish, and Khitish. And Millard, kindly see Millard. Shaptom is page 69. Sharath and Nirmal, from which Millard defendants Millard defend number from which defend number 3 and 4 comes.
And page 85 is that demarcated portion of
Yes.
Your part.
For that, Millard, kindly see Millard first page 72 first. Kindly comes to Millard page 72 first.
Yes.
Paragraph number Go Topshil Millard, kindly see what Bonkim Shapui gets
Their
at the
predecessor.
top.
No, their predecessor.
No, not their predecessor.
But
Another
they
one.
made a party.
But they were made parties. Bonkimer eta
Why are you showing Bonkim?
it will be relevant. I'll show to because kindly see Millard then Millard 2. Kindly see Millard the next paragraph after Go. Thana Taliganj such and such এলাকাধীন জেল নাম্বার কত এটা 12 মৌজা সাচ অ্যান্ড সাচ গ্রামে ডি সার্ভে সেটেলমেন্টের 159 নম্বর খতিয়ানের 53 একর 58 শতক অর্থাৎ দেশীয় 80 হাত রশির মাপে 162 বিঘা বিঘার কর্তি হারাহারি সামথিং খাজনা উক্ত জমিদার শ্রীধর চন্দ্র রায়ের সেরেস্তায় আদায় দিতেন। এই জমি জমি জমার মধ্যে চিহ্নিত হিয়ার মিলট চিহ্নিত 10 বিঘা জমি হারাহারি খাজনার টাকা এই জমিদার সেরেস্তায় আদায় দিত। Therefore Bonkim got Millard demarcated Millard 10. Then Millard kindly come to page 85. Kindly comes to Millard 6, the second paragraph.
20 বিঘা বাদে
Exactly. চিহ্নিত 20 বিঘা. Therefore Bonkim's part, Jyotish Millard Khitish's part Millard goes out.
Their defense is that this is manufactured in that objection or reply.
Reply to my affidavit in opposition before the trial court. But Millard, as of today, Millard, plaint has not been amended. Yes. Now Millard, আমাদেরটা এবার দেখাতে হবে।
ওদের স্টেতেই আছে।
হ্যাঁ, আমাদের স্টেতে।
ওদের অপোজিশন।
আমরা তো হচ্ছে সতীশ জ্যোতিষ ক্ষিতীশ।
আমরা সরকার নির্মল, এবার ওইটা দেখা ওদের ওদের অপোজিশনের কপিতে আছে।
Yes.
ওদের অপোজিশন পেজ নাম্বার
দাঁড়াও, আগে এটা দেখিয়ে দিই। তুমি now my lord kindly comes to my lord page my lord 88.
Yes, that Moroshi Mukherjee.
Mouroshi Pokarari. Kindly see my lord page 89. Mouroshi Mokarari Patta Grohita is Kinuram Khan. And my lord kindly comes to my lord page 91. My lord, who is giving my lord kindly see my lord second line Patta Data Sridukto Babu Bonkim Chandra Sakui. Now my lord kindly see my lord what my lord let me read thereafter.
Bonkim Chandra lost title in this.
Bonkim Chandra.
He gave his entire portion.
Yes, Chinnito Dosh.
But that is Bonkim.
Bonkim.
Third one.
There,
Not, neither
yes,
you nor
yes,
there.
yes. The next I'm showing. No. It kindly see my lord the last two lines of that page. Bonkim Chandra Sakui Alipur Porgona Khash পুর থানা সদর টালিগঞ্জ জেএল নাম্বার সাচ অ্যান্ড সাচ মৌজা মাদুরদহ গ্রামে ডিসেটেলমেন্ট জরিপের 159 লর্ডশিপ উড কাইন্ড এনাফ টু সি মিলার 159 ওয়াজ গিভেন টু দেম নম্বর খতিয়ানের জরিপ জমার অন্তর্গত 411 নম্বর দাগের মধ্যে পশ্চিমে বিকৃত 10 বিঘা জমি দ্যাট ইজ হোয়াট ওয়াজ গিভেন টু আস গিভেন টু কিনুরাম দেন মিলার কাইন্ডলি সি পরের দলিলটা দেখো পেজ 100
that is Kobuliat in respect of the Pakka.
Milord, this is the Kobuliat in respect of the Patta. Milord, kindly see, Milord, page 102. Milord, kindly see Mouroshi Mokarati, Kobula, Grohita Kiri. Is Shitish.
Why are you placing this? We don't know, understand. Kinuram Khan gives it to somebody.
No. This is Milord after Milord the
Data Sri Kinuram Khan.
Yes, Milord. Data is Kinuram Khan because after the execution of the Patta, Milord, it has to freehold, Milord, the document, Milord, that is there.
The corresponding
document. Then, Milord, if your lordship would kindly see page 106.
Yes.
Kindly see, Milord, last few, Milord, Topshil Sampotti Porichoy o Chouhuddi. Milord, জেলা 24 পরগনা সাব রেজিস্ট্রি সাজানসাজ সদর জেল নাম্বার 12 তৌজি নাম্বার সাজানসাজ মৌজা মাদুরদহ গ্রামে ডিসেটেলমেন্ট জরি 159 নম্বর খতিয়ানে 411 নম্বর দাগের মধ্যে পশ্চিমাংশে চিহ্নিত 10 বিঘা জমি চৌহদ্দি therefore Milord they also Milord চিহ্নিত 10 বিঘা has been given to Milord Kinuram Khan. Then Milord kindly comes to the next page.
So therefore they gave it to him and it vested, intermediary became director under the state.
Now Milord kindly see Milord.
So what about their predecessor?
Yes.
He did not do anything of this sort.
Milord, their predecessor, Jyotish and Kritish, plenty's predecessor.
That is what we are asking. So Bonkim is irrelevant.
Bonkim is, yes.
But they are parties to the suit.
They, Milord, why I say Milord, Bonkim's heirs are also parties to the suit.
Maybe.
But this is
Bonkim
relevant.
is not asking for injunction.
Yes. Now Milord, kindly see Milord 107.
But the court says that in the arrest records their name is recorded. How do you?
I'll show to your lordship that. I'll show.
Show us that.
Yes. Kindly see Milord page 107. Kindly see at the top right extreme right hand side Khotiar number 153/2. Milord, this will be very relevant. Court misses this. Court only proceeds on 153/1. Definitely in 153/1, Milord, their names are recorded. Kindly see this, Milord, after Milord arrest, Milord, Estate Acquisition Act, Milord, came into operation. Kindly see Bonkim's name is there, Milord, at the top, Milord. Then, Milord, kindly see Otro Sotter Bivoron or Dakholikar. Milord, kindly see Rayati Kinuram Khan.
Yes, seen.
Rayati, therefore, Milord, and on the right hand side, Milord, kindly see, Milord, there is a circle, Milord.
Yes.
রায়াতি দখলে সত্ত্ব বিশিষ্ট
তারপরে এটা কি রে 1351 সন হইতে
1351 সন হইতে therefore Milord the Kinuram Milord Kinuram's name, my lord, was recorded by virtue of the Estate Acquisition Act. Now, my lord, what they want to say, then, my lord, kindly see the 109. Kindly see 109.
Yes.
Kindly see Satish Chandra Shapui, Gong, and others. And on the right hand side at the top, kindly see Khotian number. This becomes 153/3. And my lord, on the bottom, kindly see Rayati Shatto, Kinuram Khan. And on the right hand side, my lord, kindly see Rayati Shatto, Dakholikar Bishishto.
Yes.
Now, my lord, kindly takes up, my lord, the affidavit in opposition, my lord, filed by my learned friend. Oh. Right. Page 14. Lord, the high. Kindly comes to page 15. 16. Milord, there are 2 page numbers, Milord. Kindly comes to 16.
Oh, sir, Bhattacharya and Mr. Ghosh, if you are hearing so much, we'll dispose of the appeal itself.
I'm placing the appeal.
What will remain if you grant stay or refuse stay?
Stay means, Milord, virtually allowing the appeal.
Virtually allowing the appeal. So, yes, Mr. Ghosh, should you take it up today or?
As your lordship pleases.
So, we are taking up since we have heard so long, we have let us. Yes.
Milord, kindly see, Milord, at the top right hand side, 153(1) by 1. Milord, this is what is.
Which 15, page 15.
Page 16, Milord, it should be. It is 15 or 16? 16.
153 by
1. This is what, Milord, the learned trial judge records in the impugned order.
Yes.
Now, Milord, kindly see on the Rati column, Milord, kindly see Bonkim Chandra Shapui, Satish, Jyotish, Khitish. Definitely their names were recorded.
153 by 1 is also a part of the suit property.
153, yes. One Khotian number.
Even if in respect of a part their name is recorded, they remain a co-sharer. At least on the basis.
This is, Milord, after, Milord, a registered document, Milord, has been executed. Milord, whether record of right, Milord, will have precedence.
Mouroshi Mukaradi was not, could not be registered. I mean,
could not be, but original partition deed is there. Even if we leave aside, Milord, the Kinuram Khan's, Milord, interest. And as of today, the plaint has not been amended. I'll show to that part also to your lordship.
No, if the plaint was amended, Mr. Ghosh would say that. No, plaint has not been amended. You
counter affidavit ta dekha.
Page number 27.
What? For
page
what?
27.
In prayer?
No, counter affidavit to my affidavit in opposition.
Oh, the allegation that it's page?
Milord, it is, Milord, at page 27 of opposition, affidavit in opposition. Kindly see, Milord, at page 31, para 16 and 17. May I place that the plaintiff state that the
original was produced?
Photocopy.
At the injunction stage. You have the original.
Oh, this was copy. No, produce at the time of injunction hearing.
Certificate copy.
Certificate volume
copy. No original copy produced.
What? No original copy? Certificate copy from the registry.
Filed an application with the trial court for verification of this document.
They're not pressed. That order is also there. They're not pressed. That's why, Milord, we annex, Milord, the order sheets of the in the application. They're not pressed. The kindly similar 31, Milord, para 16 and 17, that the plaintiff state that the defendants have falsely stated and or mentioned to as to a partition deed being 465, which is a fake document, but Sanjeev Shapui Sukumar
court চলে গেল 153 by 1 যদি যায় তাহলে সেটা রেকর্ডিং তাহলে 153 by 2 or 3 What is the stage of the suit?
Injunction, my lord. Issue
has not been
filed.
Yes.
The plaintiff that these defendants have falsely stated and are mentioned as to a partition deed being 465, which is a fake document. That's why
this.
State then Millard kindly see
Kinuram cock and bull story.
Kinuram's Millard, they have a Millard denied Millard Kinuram Khan's existence. Millard, these are the main Millard objection Millard in their counter affidavit. Now Millard and Millard they say only Millard since in 153/1 their predecessor's name are there, they are still a co-sharer. And that is being recorded only by the learned trial judge. It's not a case, Millard.
153/1 that fell in their portion as per the partition deed.
No, wrong. That is the wrong record. 153/2 and 3 were their part.
Later দেখিয়ে দিচ্ছি না। Let me check.
No, 10 বিঘা করে ওটা রেকর্ড।
হ্যাঁ ওটা দেখে নাও।
আচ্ছা 108
107 108
এটা হলো 109 হ্যাঁ এই যে ফিট নাম্বার 100 3.3 acres মানে 10 বিঘা এই যে 3.3 acres মানে 10 বিঘা
আর এখানে
তো আমাদের বাকিটা
এখানে কি রেকর্ড হচ্ছে
এদের সবার নাম এদের নাম বলো টোটালটা এই তো 46.42
এটা আমাদেরটা
yes
if your lordship would kind enough to Millard compare page 109 of the Millard stay application
with what
page Millard 40 and 41
of the same
of the stay application
page 109 with 40-41
109 of the stay application
and
with Millard
page 16 of the opposition
page 16 of the affidavit in opposition
17
yes
kindly see 109
এটা টোটাল
kindly see Millard Sotish this is the Millard Sotish Jyotish Khitish's Millard
this is RS
this is kindly see Millard at next page what is the total Millard that has been recorded 3 acre 30 at the top right hand side.
Which one
at page 41
no.
At page 110 at page 110 at the top right hand side wrongly record হয়েছে
এটা আমাদের টোটালটা আমাদের ওদের 3.30 আর বঙ্কিমের 3.30 সেটা হচ্ছে রেকর্ড হয়েছে
3 acre 30
and now Millard kindly see page 16 of the
3 acre 30 that decimal
3 acre 30 yes means 10 bighas and Millard in here Millard it has been wrongly recorded in page 16 kindly see 17 at the bottom 46
এটা ঠিক আছে পরিমাণটা ঠিক
.42 but their name has wrongly been recorded
no that is 153/3 and this is 153/1 different butterfly
plot na eta
Khotian that is the Khotian that is the Khotian well this is the wrong recording
151/3 is the record of the Khotian for the particular
this is Millard the wrong recording.
What is wrong record? Which one is wrong?
Millard 17 page 17 at the bottom Millard kindly see 46.42 which ought to have been recorded in the name of the predecessor of the Millard defendant number 3 and 4
What was the name of the defendant their predecessor?
My predecessor
name is Jyotish Chandra
defendant 3 and 4
Sharat and Nirmal and they come from Millard Jyotish Khitish and
no I'm come from Jyotish only
very well
from Jyotish only
very well on Jyotish
21 2 and 3
but schedule was given to 3 brothers Jyotish 3 brothers
so at least regarding 153/1 it may be wrong recording but which one is wrong we have to that
well my friend just now says 151 is the previous thereafter 151/2 was prepared in the name of Kinuram
yes
thereafter 151/3 which is in my name so it's rightly recorded after 151/2 Kinuram's name was there after 151/2 there but
150/3 is Rati Sotto in favor of Kinuram
By virtue of them.
By virtue of them, Satish Gong.
Yes. So this is all.
This is thing.
Completely.
This is on factual aspect and
Legal aspect.
I mean, yes. Now, my lord, kindly comes to the prayer in the plaint, which is page 26 of the my lord.
For what? It's a partition suit usual prayers.
Yes, A. Kindly see. Share.
Read out.
A decree declaring that the plaintiffs are the owners of equal 1/108 share. My lord, whether equity, my lord, can be exercised.
partitions
1/108 millard minuscule share millard has to be looked under a millard binocular. Whether millard to the extent of millard, whether this injunction can be granted millard to the inconvenience of so many other co-sharers millard, where there has been admittedly several millard transfers from other co-sharers. Page 26. This is millard deviation millard from the orthodox view, but
yes. What injunction has been granted?
Status quo with regard to nature, character, position, third party interest. আর কি বলার আছে
আমাদের দিকটা আগে ল পয়েন্ট ট্রাইবাল ইস্যু আমাদের দিকটা আগে সেটা আর ওদের আমাদের দিকটা আগে অ্যাডমিটেড ডিটেল লেখা চিহ্ন
Yes.
You know that these are on fact.
Yes, kindly see the page 28 of the injunction application, the plaint, the schedule of the plaint.
Yes.
Kindly see the schedule. RS doc number 416, 417, 418, and 420. But as of now, we have only heard on the point of we have only submitted on the point of plot number 417. There are other spots also. I request my learned friend, the lordship, he definitely shows to your lordship these 416, 418, and 420 are the part and parcel of the said lordship, the partition deed.
Are part and parcel?
They require to show that they are the part of the parcel.
They are not, you are saying?
No. Firstly. Secondly, my lord, kindly consider regarding plot number 417. Now, my lord, my learned friend shows to your lordship the portion of the deed that is page 86. And also the deed of Morosi prepared in favor of the Ted Kenuram. But may I read for your lordship the page 86(1) জেলা 24 পরগনা থানা টালিগঞ্জ এলাকাধীন জেল নাম্বার 12 মৌজা মাদুরদহ গ্রাম সেটেলমেন্ট জরিপের 501 নম্বর খতিয়ানে নামজাদা পাইকের ভেরি, ইটস আ ওয়াটার বডি, এত শতকের অর্থাৎ 80 হাত রসিদ মাপে জমির মধ্যে বঙ্কিমচন্দ্র সাপুই দিগর চিহ্নিত 20 বিঘা জমি হররি খাজনা শ্রীযুক্ত বাবু শ্রীধর চন্দ্র দিং শ্রেষ্ঠায় আদায় দিতে হয়। This is regarding বঙ্কিমচন্দ্র. Now, I could not find, my learned friend definitely shows to your lordship, regarding Jyotish Chandra, my predecessors. Bankim Chandra is not my predecessor. My predecessor is Jyotish Chandra. Bankim Chandra's predecessors are defendant number 13, defendant number 14, defendant number proforma defendant number 2, proforma number 3, proforma defendant number 1, proforma defendant number 4, and defendant number 14.
Jyotish's name is there in the partition deed.
Name is the partition deed.
Then
all property this particular 417, 416. I have showed to your lordship the suit plots. Suit plots are 416, 17, 18, and 20. These plots are not mentioned in the partition. Let my understand show the single document to that.
But does the partition deed mention any plot?
But they can say because they have annexed only a portion of the partition, the certain pages of the partition.
Not the entire partition.
Not the entire partition.
Okay. We
Not
have the original. We have the original.
They have not annexed.
We are concerned with Milord Shotish Jitish Khitish and Milord the.
But it will not help, my lord, because all lots of dogs are required. What are the dogs? What are the area of the particular plot of land? It's required.
opposition
Actually,
Have
Milord.
annexed the entire deed.
yes.
Milord, secondly,
Opposition
Yes.
Milord, kindly come to my
দাগ নাম্বার ছিল 159 ওরাই তো বলেনি এগুলো
opposition, my lord. Milord, kindly come to page 18 of my opposition.
Yes.
This is an information received from the concerned BLRO office on 6th July 2015. Milord, kindly see page 18, 19 and 20. Milord, kindly see page 18 first. These relate to Milord, RS plot number 417. Milord, Thana, Milord, kindly Milord, kindly see the remarks. RS ROR Dagir Ukto Dagir plot number 153/1, 153/2, 150/3 রায়তের নাম বঙ্কিমচন্দ্র সাপুই, পিতা কেদারনাথ, সতীশ চন্দ্র সাপুই, জ্যোতিষ চন্দ্র সাপুই, ক্ষিরিশ চন্দ্র সাপুই, রাজকৃষ্ণ সাপুই, মনমোহিনী দাসী, স্বামী সোয়ানসো. Their names are there till today. That is on 2015. RS is existing in my name. The next page, the regarding dag number 418, similar. That is on 15. Malad, thereafter page 20 is dag number 420, and lastly page 21 is page 460. But these issues are required to be dealt into by full-fledged trial. Firstly, secondly, why I came before the trial court with an injunction application. This is a water body. Now, the appellant before your lordship, they have, I come to know, they have lordship made an agreement. A development agreement with the developer, who is the power of attorney holder, who is affirming this affidavit and all, to convert this water body into a landmass and raised a high rise. That's why I had asked the trial court. Even maybe I have a minimum share in the property, but it's not only the share, it will converted the entire water.
Have you alleged that anywhere in your injunction?
My injunction application is there.
You have alleged.
I have written. May I show to your lordship my injunction application? My learned friend has annexed.
Yes, page 39.
Yes, my lord.
Political interest.
38 and 39.
38 and 39.
Paragraph 19 onwards. Help of surveyor started surveying and measuring the vacant portion of the suit plot and collected building materials for construction of building without any demarcation.
Don't say it's a water body. Building material, how can building material be collected on water body?
No, but this is still today it is recorded as bill. Bill means one water body.
You are saying something else in your injunction. You said they are trying to
I have
convert
annexed the
conversion allegation is not there. Surveying, measuring vacant portion of the suit property, collected building materials.
May I put to your lord?
How can they collect building materials on water body?
Complaint. Complaint.
It's not part
But I
of
have
the
put to your lord.
Not a single allegation regarding water body conversion. Rather, it appears it's a solid land.
Achha, na?
এটা দেখে মিলিয়ে দিই।
দেখো তুমি দেখো একটু দেখো। আচ্ছা আমি দেখেছি।
It don't says land.
You are saying illegal construction, not.
No, but I have showed to you. I'll give it to you.
Page 42 schedule says land.
Yes.
What is the bill?
28.
That is beyond the field. Making construction on the suit property, etc. That is your prayer and abandonment. And you discover land at page 42. He's right.
অত লাভ আসলে করা।
দেখা তো দেখো তো।
Whatever you are ignoring, but it might have been shown as whatever what your allegation is something is. But first of all, your argument is partition D does not contain the other thugs apart from this that 17, 417.
Yes.
And secondly, that your current record of rights reflect your names, your
Till today.
but they are your predecessors.
The Jyotish Chand is my predecessor.
But the
Jyotish Chand
predecessors' name are still recorded. They have died. Then that
No, that
itself
is
is
the highest record of right. LR is still in the name of their name. That's because in the meantime, maybe some person some sold certain portion. This is my
yes.
Samila kindly comes to the schedule of the plaint, page 28.
Schedule was the same as the injunction schedule.
Kindly see what they have stated. My lord, the RS Khotiar number 153/1, CS Khotiar number 159. RS DAG number 416, 417, 418 and 420. Now, my lord, kindly see their affidavit in opposition, page 14.
Yes.
Kindly see at the top, CS Khotian 159. Kindly compares. Then, my lord, kindly compares with the schedule. CS Khotian is 159. Then Miller kindly see what they say. RS DAG number 416, 417, 418, 420. Miller kindly see Miller the next page, page 15. Miller, what are the RS DAG from CS Khotian? 420, 412, 414, 415, 404. Therefore, they are not sure about their own case. What are the RS DAGs? This is their own document. And admittedly, this is Millard is his name Millard on Gunamoni Shapui state, which is who is the predecessor in interest of all the 7 parties, and she executed the deed of partition.
No, all of them executed it.
They were not sure, Millard, what is their Millard suit property.
But your partition deed does not mention the other thugs.
Partition deed says only Millard share. Otro ongsher chinnito.
We cannot be sure, and current record of rights reflect there.
Well, may I ask myself, what is the current record of rights? Their plaint schedule, Millard, has to be Millard in accordance with the then current record of rights. They Millard completely Millard.
But no, Mr. Ghosh has also relied upon the next few pages.
Yes, yes.
That page 17, 18,
18, 19,
18, 19 onwards. There the DAG numbers are written 417 and all. Their predecessor's name is there. DAG number 417. All of them are there.
But this is only Millard information, Millard.
Information given by the
BLRO.
Millard. Yes,
BLRO Kosba.
BLRO Kosba, Millard, just like Millard, this is Millard from trial.
We are only on tribal prima facie case. Only on that.
Millard, this is the Millard partition deed as of today, not challenged, cannot be Millard.
Partition deed, yes, it is one that it has to be ascertained by, I mean, comparing with the actual property, suit property as to whether that covers these DAGs.
Therefore, then Millard, Jyotish Kiti Shiti, by admittedly Millard had Millard given it to Kinuram Khan. Admittedly. Although
we are
Millard
concerned only with whether they have any share.
Exactly.
And whether the property is demarcated or not.
Demarcated, I have shown to your lordship, even Bonkim share, their share, all Millard, Chinnhito Dosh, they have got in the partition deed out of 162 bighas.
Does the partition deed mention any DAG?
As it appearing from the service copy, but there's nothing. I don't know.
72, Millard, page 72.
If there is no DAG, Mr. Ghosh, then the Khotian is covered.
No, they have not said this 10 bigger in respect of which plot.
And if there is no DAG Millard, then entire Khotian Millard 153 and Bata of 153, 1, 2 and 3
but here the
all
Khotian has been given 159.
CS, that is CS Khotian, that is also
now Leonard Friend says that 416, 417, 418, 420 are not part of the CS Khotian 159.
No, they say that CS Khotian has been given. The entire CS Khotian regarding that entire
My lord,
CS Khotian
yes,
these
my lord.
portions.
My
The entire CS Khotian covers your plots also. That is what they are saying.
my learned friend says CS Khotian 159 covers 410, 412, 414, 411, 404.
Whatever is there in the, it's the other way around. They say entire 159 was demarcated between themselves.
So then, but
And whatever plot comes within that, you have shown regarding certain particular plots in that CS Khotian number.
But may I subject to correction, my lord? CS Khotian number 159, if it is came within the purview of this lordship, the partition deed, the CS Khotian 159 subsequently lordship the
You
plot.
seek some portions of CS Khotian number 159 only.
They have seen.
Your suit property is some plots in CS Khotian number 159.
And
but if the entire CS Khotian has been distributed and by partition deed, registered partition deed,
the
presumption of correctness is attached to that.
There are
You're
other
merely saying it's manufactured would not do, Mr. Ghosh. Then there is no prima facie. The prima facie case is that it's already a demarcated property, the entire 159.
my lord, that's
That be so, Mr. Ghosh, then how can you claim partition by saying that it's a joint property?
But not only 159, there are other properties also. But the suit property does not come within the purview of 159. Though it is in the plain, in the schedule.
Property is definitely
Yes,
within 159.
in the schedule they have written that the suit property is under 150.
Your schedule.
Yes, yes.
They have what they have written.
I'm sorry, my lord.
Your suit property is CS Khotian number 159, entirely comprised of CS Khotian 159.
That has been written in the schedule. But I cannot.
You have got an injunction on that only.
And my lord,
159, if the partition deed, registered partition deed is there, Mr. Ghosh, how can you earn 108th share in that property? On the strength of that, you get an injunction over the entire property.
my lord,
Can be probably compensated by OLT even if you win the suit.
my lord, kindly consider
108, would you be able to construct a property even there?
there must be there is some maybe some
Correction hoyni.
Correction.
What correction?
But this that RS Khotian has been given correctly regarding the RS Dag number, but the CS Khotian has been given wrong. RS Dag number.
All their documents are on CS Khotian, your documents are on CS Khotian.
My documents are on RS Khotian.
See, CS Khotian number 159 is given. Page 14, that is not your document.
Yes, yes.
Page 14 of your affidavit of opposition.
It's 14.
Yes.
See the Khotian number?
But kindly see the next page. What are the properties attached to? That is why I said this was wrongly recorded. That is why I said.
But these properties which are attached to it are different dags.
Different dags. These are not part of
your
the
suit cannot stand on the face of the plane.
No, but if it
on the
is
basis of your documents.
That is not the case in the plaint.
But the RS Khotian is the correct.
You cannot get an injunction order on the basis of this because your document shows CS Khotian number. The documents which you produced pertain to some other property, some other DAG numbers. None of these DAG numbers tally with your DAG numbers.
It says not.
So therefore, on the basis of these documents itself, you are not entitled to get injunction.
The fact is that it should be other CS number because the RS Khotian is correct.
Two things we are concerned more with two. Kinuram, we are not so bothered right now. Part of the property might have been given to Kinuram, it might have vested. We are not interested in that. Even if you show a minuscule share in the property, we can understand. But then, minuscule property for 108 share, you should not get an injunction restraining construction over the entire property.
I cannot show.
At best, we can restrict the injunction to your 108th share, but that would create troubles. And because on the face of the plaint and your documents, you have failed to prove that you have any title regarding this property. Your documents say Khotian number, CS Khotian 159, but different DAG numbers. But yes, some of the documents, but that is information slip, he is right on that. Information slip, I mean, there's a title deed, partition deed, which covers entire 159.
But
some of your documents contradict your information slip. That is a difficulty, Mr. Ghosh. How can you get an injunction on the basis of this?
The RS Khotian has been given correctly. And
that is what you are interpreting from the bar.
No, that's from the
documents pertain to CS Khotian.
But the
all your documents pertain to CS Khotian.
CS number has been given.
CS number has been given.
Wrongly given, Malad. That's true, Malad. I cannot overcome this.
Even if RS Khotian you say is correct, how do you know that is correct and CS is incorrect? It may be the other way around.
But that's required at trial.
Because
That's required a trial.
does not require a trial. Your plain schedule refers to CS Khotian. Your documents refer to CS Khotian. So by
CS Dag. CS Dag.
your documents relate to CS Khotian 159.
Yes. Yes.
So your documents as well as your plaint relate to CS Khotian 159. So the presumption should be that RS Khotian is wrong, not CS Khotian. Your documents, your plaint, nothing is theirs. They only produce a title deed, partition deed, and say that entire 159 was divided. So it's demarcated. So it's not a joint property. And this coupled with the fact that 108 share, that's the current view, Mr. Ghosh. A minuscule share. You can be compensated ultimately by OLT1.
But not to kindly consider the
108 rupees, maybe.
No, man, it's a huge area, 64 bighas.
64 bighas.
64 have sold out. যাই হোক, as of now, 64 bighas.
Mr. Bhattacharya might have also purchased a portion of it. Where is this? South 24 Parganas?
South 24.
He may be the owner of a part of the property.
Part of us. And maybe one third.
Benami.
Maybe one third.
Maybe more.
Near Peerless Hospital.
Near Peerless Hospital? Go for mediation. You should go for mediation to cut short this suit. But they'll charge you. No, let us, Mr. Ghosh, you cannot get it.
Not kindly consider this, but the entire, the
They have given you the reasons also why.
No, but they only said only regarding the plot number 47. That is plot
We have
number.
this notion that as a partition suit, in a partition suit, it's a matter of right injunction. Otherwise, generally it is. But here the documents, your documents go contrary to your schedule.
CS Khatian,
you cannot improve it here. How can you?
But I cannot.
You did not draft the plaint.
I'm not cannot improve it. But from the schedule it shows. From the schedule of the plaint it shows. But in the body of the plaint,
this was ad interim or injunction application?
No. Contested.
Disposal of injunction application.
No, Mr. The present appeal arises out of.
Well, at least my right may be protected, my lord.
How? You don't have a right on the basis of your papers.
Yes.
The present appeal arises against an order of temporary injunction in the form.
We are in tilting position, my lord.
In the form of status quo in respect of nature, character, possession, and alienation of the suit property. So, next para, the plaintiff stroke respondents filed a suit for partition and obtained the impugned order of injunction on the basis of their averments made in a temporary injunction application filed therein. Full stop. The injunction application was contested by the defendants. You are which defendants?
3 and 4 only.
You only contested.
No. Others also contested. Appellant is the
by the defendants by filing written objection. Full stop. Next para. Defendant numbers 3 and 4 have preferred the present appeal. Full stop. Learned counsel for the appellants argues that a registered deed of partition in respect of CS Khotian number 159 was produced by the defendants before the trial court. Full stop. The flimsy objection thereto, comma, that too in the rejoinder filed by the plaintiffs in connection with their injunction application, comma, was a denial on the ground that the said document was manufactured. Full stop. However, comma, it is argued that till date no amendment has been sought in the pleadings of the suit challenging such registered deed. Full stop. Next para. It is argued that the learned trial judge overlooked the said registered deed of partition in favor of purported information furnished from the BL and LRO, comma, indicating that the names of the predecessor in interest of the plaintiffs were recorded in respect of the suit property. Full stop. Next para. However, comma, learned counsel for the appellants argues, comma, documents pertaining to Mouroshi Mukarrari Patta having been granted by some of the original co-sharers, comma, who are parties to the partition deed, comma, in favor of third parties were also produced by the defendants, full stop. By dint of such transfers, comma, the said original co-owners lost their title even in their demarcated portions by virtue of the operation of the West Bengal Estate Acquisition Act 1953, comma, since the intermediary rights vested with the state. Full stop. Next para. Learned Counsel next contends that even on the documents produced by the respondents, comma, it transpires that the names of the predecessor in interest of the plaintiffs were recorded in respect of dag numbers which do not tally with the plot numbers mentioned in the schedule of the plaint and the injunction application. Push up. Next para, it is submitted that the plaintiff stroke respondents have claimed a minuscule 108 th superscript করে দেবে 108th share in the suit property, but has been granted injunction disproportionately over the entire suit property, comma, to the gross detriment of the interest of the defendants. Full stop. Accordingly, it is submitted that the impugned order ought to be set aside. Full stop. Next para. Learned Counsel for the appellants, comma, before parting with the matter, comma, also seeks to place reliance on an alleged deed of gift executed by the predecessor in interest of the defendant stroke respondent number 1 in favor of the said defendant plaintiff stroke
number 1
plaintiff stroke respondent number 1 in his favor, comma, wherein it is admitted that wherein the existence of the partition deed relied on by the defendant's appellants is admitted. Full stop. However, comma, it is candidly submitted by learned counsel for the appellants that the said document was not a part of the trial court records, comma, nor produced before the trial court, for which an application under Order 41 Rule 27 has been filed before this court to bring the said document on record. So next para, learned counsel appearing for the plaintiff's respondents controverts the submissions of the appellants and contends that information received from the BL and LRO have been produced to indicate that till date, comma, the names of the predecessors in interest of the plaintiffs, comma, namely Jyotish Chandra Safui, namely Jyotish is your predecessor.
Yes.
Namely Jyotish Chandra Safui is reflected in respect of the suit plots. Full stop. Next para, it is further contended that none of the dag numbers are mentioned in the partition deed produced by the defendants, and comma, as such, comma, it cannot be ascertained whether the said partition deed dislodges the claim of title of the plaintiffs. Full stop. Next para, learned counsel for the plaintiffs respondents also seeks to argue that the suit property has been recorded in the records of rights as a water body, and efforts are being made by the defendants appellants to convert the same, comma, due to which there is all the more urgency to grant injunction. Full stop. Next para. Upon hearing learned counsel for the parties, comma, we find several discrepancies in the plaint case on at a prima facie level. Full stop. Next para. Even without looking into the document within bracket purported gift deed bracket closed sought to be relied on by the defendants appellants before this court for the first time, comma, The documents produced before the learned trial judge would suffice to indicate that a registered partition deed in respect of the entire CS dag number, CS Khotian number 159 was produced by the defendants, by virtue of which specific demarcated portions were allocated among the predecessors in interest of the parties, which precludes any further inference as to the suit property still retaining its joint character. Full stop. As rightly argued by the appellants, till date there is no challenge in law to the said registered partition deed, and as such, a presumption of correctness is attached to the said registered deed. Full stop. Next para. In the said deed, it transpires that the entire CS Khotian number, within which all the suit plots fall, has been covered. Full stop. Thus, there is sufficient prima facie doubt as to whether the suit property retains its joint character at all. Full stop. Next para. Insofar as the documents produced by the plaintiffs themselves in the trial court, there is discrepancy inter se such documents. Full stop. Next para. In the extracts from the records of rights as annexed at page 14 of the affidavit in opposition filed by the plaintiff's respondents in this court, it transpires that with regard to Khotian number 159, the recording has been done in respect of plot numbers 410, 412, 414, 411 and 404, none of which come within the ambit of the suit property. Full stop. The suit property covers RS dag numbers 416, 417, 418 and 420 of CS Khotian number 159. Full stop. Next para. Although the RS Khotian number 153 by 1 has been stated in the schedule of the plaint as well, no corresponding document regarding RS Khotian number 153 by 1 has been produced even by the plaintiffs themselves in the trial court. Full stop. Next para. That apart, we accept the contention of the appellants that in view of the plaintiffs themselves having claimed a minuscule share of 108 in the entire suit property, the grant of injunction in respect of the entire property, covering several plots, would be contrary to equitable principles. Full stop. Next para. We find from the impugned order that the learned trial judge, although referring to the registered partition deed, merely proceeded on the basis of the one line denial of the same in the pleadings of the plaintiffs, without taking into consideration that no challenge in law has been preferred thereto till date by the plaintiffs. Full stop. Next para. The learned trial judge further relied on RS records of rights, which themselves contain discrepancies as pointed out above. Full stop. That apart, it is well settled that if pitted PITTED against documents of title, the RS records of rights, which merely raise a presumption as regards possession, have to give way. Full stop. In the present case, since the registered deed of partition regarding the entire CS dag number 159 has been produced by the defendants in the trial court, there was no scope for the learned trial judge to override the same by placing reliance on records of rights, which itself contain discrepancies as well. Full stop. Thus, on the basis of the pleadings and documents which were before the learned trial judge, we are of the opinion that the learned trial judge erred in law and in fact in granting injunction in the form of status quo, since no prima facie triable issue has been raised by the plaintiff stroke respondents sufficient to grant an order of injunction in their favor. Full stop. Next para. Also, comma, since only 108th share in the property has been claimed, comma, the balance of convenience and inconvenience is against the grant of injunction. Full stop. Also, comma, since there is scope of grant of royalty money to the plaintiffs stroke respondents at the end of the litigation in view of their share being minuscule, comma, we do not find any irreparable injury sufferable by the plaintiffs if injunction is refused. Full stop. In such view of the matter, comma, on consent of parties, comma, we decide the appeal along with the connected applications. Full stop. We do not find any necessity, comma, in view of the above orders, comma, to adjudicate on merits can 2 of 2026, comma, which is an application for production of further evidence. Push up. Accordingly, we dispose of can 2 of 2026 with leave to the appellants to seek to rely on the document annexed thereto, comma, if deemed necessary, comma, in the trial court uh, in due course of law. Full stop. Next para. With regard to FMA 1, with regard to the main appeal, comma, we dispose of the same as follows, colon, FMA 116 of 2025 is allowed on contest, comma, thereby setting aside the impugned order dated November 30, 2024, passed by the learned civil judge, senior division, 4th court at Alipur district, South 24 Parganas, in title suit number 204 of 2016, and dismissing the temporary injunction filed by the plaintiff stroke respondents in the trial court. Full stop. Next para. Can 1 of 2025 is consequentially disposed of as well. There will be no arrest to costs, comma, next para. We make it abundantly clear that the above observations were rendered only tentatively, comma, for the purpose of disposing of the appeal and shall be construed to be restricted to such disposal only, whose of such observations shall not uh, affect the rights and contentions of the parties or unnecessarily prejudice the learned trial judge while disposing of the suit itself on its own merits in accordance with law. Full stop. It is expected that the suit being of the year 2016, comma, the learned trial judge shall expedite the disposal of the same uh, as far as the business of the said court permits. We are not fixing any timeline, Mr. Ghosh, because if the suit is dismissed, some different timeline. If preliminary degree is passed and final degree, we cannot say 6 months. So therefore, we are not specifying any time.
Even this is of issue stage now only.
That's why we put in a one line, because we have refused injunction in any event. So suit should be expedited.
I'm grateful to you.
Much obliged.
Before rising, my lord, may I just draw your lordship's kind attention?
Yes.
Lord, yesterday my lord has been pleased to pass an order. Sir, my name was wrongly recorded. My lord.
It will appear as to be mentioned. Just hand over a slip, right to be mentioned. And
Below, item number 25, the learned senior counsel is not present in the court today, my lord.
25?
Yes, my lord.
You are there, you ask for time when the matter is called on. But has a very well call it on. 25 to call karo. You are for the petitioner?
Yes, my lord.
Who is for the other side?
No, the other side has not.
So you are asking for this week's time?
Yes, my lord.
On the prayer of the appellant stroke petitioner, the matter is adjourned till January 27, 2026.
My lord, item 26 also, my lord.
It's what?
My lord, an adjournment for 2 weeks, my lord.
Which for the other side? You oppose?
No,
No,
my
why
lord.
don't you oppose?
The talks of settlement have almost been finalized.
No, we'll take it up after. We remember, talks of settlement cannot go on forever. We'll decide it on May.
আমার ছবিটা আসবে।
Item number 26.
For the appellant, my lord.
Yes.
My lord, against an eviction, divorce decree, my lord, on ground of desertion and my lord, cruelty. I preferred and filed this application for my lord, maintenance. But during pendency of the application, my lord, they my lord, have offered a my lord, permanent settlement if my client agrees to that. We have not arrived at some figure, my lord. If your lordship gives us 7 more days, possibly, my lord, it can be
15. Fortnight's time.
Fortnight, then we'll send it to mediation, Mr. Banerjee.
It's not required.
We have
It's
agreed
not-
to a figure.
we have
possibly
already
filed
agreed
the
This is going on from the beginning of this year.
No, no, my lord. Only on the last occasion, my lord, the time was short.
Possibly we
That was
can
on
come
5th
back.
of January.
Next time, my lord, we can come
No,
back.
no.
Possibly we can come back with an application for my lord, terms of with the terms of settlement.
Very well. On 5th of January 2026, comma, when the matter was last called on for hearing, comma, it was expressed by the parties that talks of settlement were going on. So even today, comma, at the time of call, comma, it is submitted that the matter be adjourned for a fortnight for culminating such settlement efforts. So next para, as a last chance to the parties to arrive at a settlement, comma, the matter is adjourned till February 9, 2026. So it is made clear that in the event the parties fail to reach an agreement in the meantime, comma, uh, the matter would either be taken up for disposal on merits, comma, alternatively, the matter may be sent to mediation to facilitate resolution by amicable settlement. Thank you.
Item number 27.
This matter, my lord, I am appearing.
Yes, Mr. Chatterjee.
My lord, on the last occasion, there was a direction upon me, since there is an allegation against the
Advocate.
learned advocate, so that I was directed to send the copy to the learned advocate. But instructed it is
received
already
Yes.
received. Check kojo.
Item delivered.
Item delivered. It shows delivered on 8th January
But it
2026.
shows the HO, Tinsura HO.
My lord, here item delivered Chinsura HO.
Not to the addressee.
But not to the
Anyway, yes. What is the
my lord, this was required, my lord. There's 7 total delays. Says 790 days delay was there.
790.
790. Para 2 and para 7, I have explained, my lord.
appeal is against what?
Appeal is against the order, judgment dated. It was a partition suit, my lord.
Oh.
And in the partition suit, we have proceeded, but
After challenging
that
what?
we did-
Preliminary degree of partition?
Preliminary degree of partition. Decree of partition, ex parte decree of the partition.
Preliminary degree or final degree?
Final degree.
Final degree of partition.
Ex parte.
So what were you doing during the review? You have just stated that due to laches of the advocate.
Yes, I could not participate
You
because
have not even stated that you have been inquiring about the matter.
my lord, that is the
It's your duty also, Mr. Chatterjee, to as a litigant to look after the
matter.
if you are negligent, we don't find any bona fides on your part.
My lord,
Say that thereafter you made an application. Let us see. Para 2 you have stated there was delay.
Yes.
That you had no knowledge about the date of the ex parte degree.
Yes.
And it was learned advocate in the trial court who had missed the date and could not be able to appear at the date of hearing.
Yes, that was in
We don't
para-
know whether you contacted your advocate in the meantime. And then you say that your petitioners on inquiry. What prompted you to inquire suddenly?
My
That
lord,
too,
when
that too
decree was passed.
When was this inquiry made? We have not stated anything.
This is evasive, my lord. But
In 2025, you inquired for the first time.
my lord, when the
Degree was passed in 2023, March.
March.
And you have applied for the certified copy. When you applied?
My lord, certified copy was applied on. That is not written here, but I will tell. Certified copy application data. Decree শেষে যাও. Last.
Chatterjee, we don't see any reason to allow this
But,
section 5.
Otherwise, Lordship, the only thing is a partition suit, ex parte decree, and my lord,
Ex parte decree means you ex parte decree means you appeared in the suit.
and thereafter,
You did not go. There's nothing in the application to show what you did during the.
my
So
lord,
you don't find any bona fides.
kindly come to
790 days is too much.
kindly come to the report of the partition commissioner, my lord. If your lordship wants to
So we
enter into the merit.
won't go into the merits. Now the present standard is not that. You have not disclosed anything.
My lord,
What were you doing during this long period? The suit was pending. You're appearing in the matter. Preliminary degree was passed. What were you doing after that? Nothing is stated here. We don't find any reason.
my lord, paragraph
only cast blame on your advocate on one single sentence. Nothing else.
the thing is that he was not informed about it.
It's not your advocate's duty to inform every date. It's your duty to inquire.
My lord, there was
nothing on record to
latches
show
on
that.
our part also. But lordship, kindly consider one aspect, lordship. Today, it's a decree of the partition, and lordship, the order, this partition commission's order, my lord, the report that made the foundation of this order, the decree, my lord. Kindly,
you are a defendant there.
Yes, my lord.
Repeatedly, you had asked for time. What was the miss case for? Miss case 37 of 2012.
My lord,
yes, Mr. Haq, what was the miss case for?
My lord, that was for my lord, the final decree, application for final decree. In the final, my lord, they appeared, they filed their written statement.
Repeatedly, they took.
They did not appear. The preliminary decree was passed. They did not contest. Subsequently, we filed an application for final decree upon appointment.
Preliminary decree also was uncontested.
Yes, they didn't contest. And my lord,
13 was there. You had an expert degree. Order 9 Rule 13, what happened to that? You have not stated anything. Thank you. দেখি মিস কেসটা কি হলো নিশ্চয়ই অ্যালাউ হয়েছিল জানালে আবার
and my lord,
দেখি অ্যালাউ হয়েছিল কি না
the commissioners at the time when the commissioners went there for commissioning the things, partition the property, they participated there
and then challenged.
They participated there at the time when the commissioners was commissioning the property. And see the ground that they had taken in the in this appeal, my lord. There's a suit property, your lordship, 35 decimals of land. My lord,
what happened to the miss case? Let us see that.
Yes.
If your lordship kindly come to para 17.
Miss case was also dismissed for default.
Everything.
Miss case was dismissed for default regarding the preliminary decree. And that was for restoration. Habitual defaulters, no message. Sorry, no. Affidavit of service filed today be kept on record. Footstep despite service, comma, the learned erstwhile advocate of the appellants, comma, on whom the entire blame has been sought to be cast by the appellants for the delay, comma, does not appear. Footstep next para. Heard learned counsel for the parties, footstep. The only explanation in the condonation application, comma, for the huge delay of about 790 days.
90 days.
790 days is that
Para 7, my lord.
The learned advocate appearing for the appellants in the trial court had missed the date and was not able to appear at the time of hearing, and that the delay was caused due to the laches of the said learned advocate in the trial court, comma, who was unable to appear at the time of hearing. Full stop. Next para. However, comma, we do not find out any whisper within the four corners of the application as to what steps the appellants themselves were taking for inquiring about the matter during the entire period of pendency of the suit. Full stop. Next para. A photocopy of the order sheet of the entire orders passed in connection with the suit have also been annexed with the condonation application. Full stop. We find therefrom that the appellants are habitual defaulters Full stop. On numerous occasions, time was adjournments were sought on behalf of the appellants in the trial court. Full stop. Thereafter, after having initially entered appearance, the appellants chose not to appear, due to which an ex parte preliminary decree was passed in the suit. Full stop. Even after taking out an application under Order 9 Rule 13 of the Code of Civil Procedure, registered as miscellaneous case number 37 of 2012, numerous adjournments were sought by the present appellants for in connection with the said matter. Full stop. Next para. Ultimately, the miscellaneous case was dismissed for default, vide order number 40 dated June 29, 2015. Full stop. Next para. Even thereafter, the defendants to appellants repeatedly were repeatedly absent at the final degree proceeding stage. Full stop. Next para. Since adjournments had been sought on several occasions on behalf of the defendants stroke appellants in the trial court, it cannot be said that the learned advocate appearing for the appellants in the trial court lacked diligence. Full stop. Next para. Rather, it is the utter lack of any explanation as to the appellants having not inquired about the suit throughout the relevant period, which is evidently the cause of the delay in preferring the present appeal. Full stop. Next para. Since the said conduct of the appellants is self-explanatory, the appellants having abstained from contesting the suit at every stage of the matter, we do not find any bona fides on the part of the appellants in preferring the appeal late. Full stop. Next para. That apart, the delay of 790 days for in preferring the appeal is substantive, and since valuable rights have accrued in favor of the respondents in the interregnum, we are unable to condone the delay in preferring the present appeal. Full stop. Accordingly, can 1 of 2025 is dismissed on contest without any orders to cost. Full stop. Consequentially, FAT 222 of 2025 is dismissed as time barred. Full stop. Resultantly, can 2 of 2025 is also dismissed. Full stop. There will be no orders to cost. No orders to cost. প্রথমেই না এফিডেভিট সার্ভিস বলেছি। নেক্সট।
Item number 20.
আবার এখানে যদি ইয়ে হয় আবার তারপর বছরের পর বছর ডিলে করে। ঠিক জায়গা রেখে গেছে।
28 minute I am for the respondent minute. I have served
আচ্ছা।
I have served minute pursuant to your lordship direction on the same date 24th December. I have served minute.
They have not appeared on the last occasion.
Last occasion also they have not appeared minute.
You are filing your opposition today.
Already filed minute. Already filed minute. Opposition already filed minute. In two application, one is with regard to section 5 and another is appropriate order minute. I have filed both every in opposition minute.
A receipt filed by learned counsel for the respondents with regard to the affidavit in opposition filed by the respondents today be kept on record. Full stop. Next para. We find from the records that the appellant remained unrepresented on December 24, 2025 when the matter was last called on for hearing. Full stop. Next para. Even today, at the time of call, none appears to move the applications. Full stop. Next para. Accordingly, can 1 of 2025 is dismissed for default. Full stop. Consequentially, FAT 223 of 2025 stands dismissed as time barred. Full stop. Can 2 of 2025 is also disposed of in the light of the above observations. No orders to cost.
May I take a snap of this receipt?
Yes. এটা ছবি তুলে নিতে হবে। Inside the courtroom, take a snap and
okay. এটা রাখুন।
Item number 29.
29 I appear for the appellant. But there is a defect in the degree.
You appear for the appellant.
I appear for the appellant.
Your appearance change 29 ফাইলে দিয়েছেন তো প্রদীপ রঞ্জন ঘোষ আচ্ছা on the last occasion ও আচ্ছা you are for the respondents for
But
their
I have
state
the CAN application.
Yes, yes.
But
What-
there is a defect in the degree. Respondent number 3 and 4 has been implemented. They have been expunged in the code below.
we'll give you liberty immediately to explain them to that 3 and 4
3 and 4. The degree also shows that.
degree shows that their name has been expunged.
No, Lordship, 3 and 4 it shows that it is subsisting. It has been expunged via order dated November 2003. Seventh of
November
7th of November 2003.
7th November. It is submitted by learned counsel for the appellant that vide order dated November 7, 2003 passed in the suit from which the present appeal arises, comma, the names of the respondent numbers 3 and 4 were expunged. Full stop. Next para. Accordingly, the decree of the trial court be sent down for effecting necessary corrections by expunging the names of the said respondents. Full stop. On the prayer of the appellant, comma, leave is granted to the learned advocate on record for the appellant to expunge the names of respondent numbers 3 and 4 from the cause titles of the memorandum of appeal and the connected application. Only one application. And the connected application during the course of the day. During the course. Move your application. What is the application? Eta feret diye din. What is the application?
CAN 1 is an application for.
Sorry, what is the appeal against?
The appeal is against an order, it's against a degree, where my suit has been dismissed on the ground, I have failed to prove.
That section 5 let us hear, then we'll come.
Trust, they for declaration and injury, it is barred by time, and his father also settled. That is
They're
the
not
merit
asking
on
for
merit.
40 days delay. What is the reason?
Paragraph number 2. Paragraph number 3. A huge time to obtain the certified copy.
Surprisingly, I obtained it.
Yes?
But I did not open my, I obtained it within 1 month. That's why I'm also, I will not open my mouth, my wife.
So, the explanation offered for the delay of about 40 days in preferring the appeal is that substantial time was consumed by the certified copying department of the trial court in making ready and handing over the certified copy of the decree of the trial court. Who's of next para? Such contention is corroborated by the certified copy such contention is corroborated by the dates of application for copy and date for notifying the requisite stamps as reflected in the reverse on the covering page of the certified copy of the impugned judgment as well. Full stop. Accordingly, in our view, sufficient reason for the delay has been explained. Hence, CAN 1 of 2025 is allowed, comma, thereby condoning the delay in preferring FAT 226 of 2025. Full stop. In view of the appeal, you're appealing for all the respondents?
No, only one respondent.
Oh, acha.
All two are to
1 and 2.
1 and 2, my lord, the legal heirs of Sunil Kumar Banerjee.
No, I am only for Satonik Banerjee.
Achha.
Not 2.
No.
But then in that event,
then you have to serve
the
copy of this application also.
The application. I thought they are on caveat on the last occasion and they
lost caveat. Both of them lost caveat.
No,
they are submitted.
দেখুন caveat
আমি জানি না।
Only Satonik.
Only Satonik Banerjee.
You won't have instruction to appear for the.
Then I have to take my.
Your mother.
I have only wakalat number for Satonik Banerjee.
Your mother resides in the same premises.
But I don't know, but my caveat contains only signature of the. As per my knowledge, if your lordship directs, I will take instruction.
No, but we cannot allow the section 5 then.
But if your lordship make it pass over, I can take the instruction over phone from the.
Let us complete the order and we'll keep it on hold. আচ্ছা কি বললাম? না এটা অ্যালাউ করে ছেড়ে দিলাম এই পর্যন্ত। You immediately take instruction and we'll give you that liberty.
My lord, your lordship passed on.
Pass over for 10 minutes. এই পর্যন্ত থাক অর্ডারটা।
I take for my
পাস ওভার থাক। এই অর্ডারটা এই পর্যন্ত কেটো না। পাস ওভার থাক for 10 minutes। এটা থাক সাইডে থাক। ওইসব বলে দিন।
Number 30.
Yes.
I appear for the appeal.
Lordship, I appear for the respondent one.
So there was a direction for service, my lord. I have served. The respondent number 1 has been duly served. The other respondents are the pro forma. Even in lower court, I did not seek any relief against them. My lord.
Move the matter.
My lord, there is a supplementary affidavit to Can 2. On the last date, I sought for the liberty. My lord was.
Can 2.
Yes, my lord.
Can 1 has to
Yes,
be
my
allowed
lord.
first?
Delay. Yes, my lord. There is a delay of 36 days, my lord, in filing this appeal. The appeal.
What is the reason?
My lord, I have explained the delay in my application. Can one know? My lord, kindly come to paragraph. My lord, the order was passed on 10th April.
Yes, we're allowing this delay.
Yes, your lordship.
Heard learned counsel for the parties, full stop. The explanation furnished in the condonation application is that since the suit was pending for more than 25 years and several orders were passed from time to time, considerable time was taken by the learned advocate to draft the appeal. Full stop. Next para, we find substance in such explanation. Full stop. Accordingly, can 1 of 2025 is allowed on contest, thereby condoning the delay in preferring FAT 260 of 2025. Full stop. The said appeal be deemed to stand registered and admitted. Full stop. Next para, in view of the appearance of the defendant respondent number 1 through its learned advocate, service of notice of the said respondent on the said respondent is dispensed with. Full stop. Since respondent numbers 2 to 4 appeared as pro forma defendants in the trial court and no relief is sought against them, service on the said pro forma said respondents is also dispensed with. Full stop. Next para. On the prayer of learned counsel, in terms of leave granted by us, the supplementary affidavit filed in connection with Can 2 of 2025 today be kept on record. You have given copy to them?
Yes, ma'am.
Yes, your lordship.
Yes. What is that application? What is the matter about?
My lord,
Can 2 now.
My lord, this title suit was filed by the plaintiff, appellant herein, my lord, for declaration in respect of 2,500 shares, my lord, which were misplaced.
Pardon? 2,500?
Shares, my lord. The appellant
Shares,
is a registered stockbroker, my lord.
Achha.
In course of his business, 2 lakh shares were purchased sometime in 95, 96, my lord.
The shares are of the respondent number 1 company.
Yes, my lord. Through Calcutta Stock Exchange.
Their shares. Yes.
My lord.
Then
Now, in course of the this
declarations, you lost those shares.
Yes, my lord. That shares were misplaced, my lord. Initially, the case was filed for 2,500 shares, my lord. But during pendency of the suit,
This is an application to produce additional evidence.
Yes, my lord.
No stay or injunction.
No, my lord.
Then will directly appear along with the appeal, the usual order.
My lord, as my lord.
Your suit was dismissed. Okay.
Yes, my lord.
There is no scope of
Dismissed ex
stay.
parte, my lord. Though during pendency of the suit, my lord, out of 2,500 shares, 1,700 shares were transferred or duplicate shares were issued, my lord. However, the learned trial court came to a conclusion that I could not prove my ownership in respect of those shares, my lord.
What did you produce in support of your ownership? You are the broker.
Yes, my lord. I could not produce the purchase documents,
So
my
these
lord.
are those order 4127.
Yes, my lord. My lord, there were several documents were produced in the evidence which shows that I purchased those shares, my lord.
Is there in addition?
However, there are additional documents. I found out the receipts, my lord, through which it was
Can
purchased.
2 of 2025 is an application under the application for leave to produce additional evidence. Full stop. Accordingly, due to the nature of such application, the same is required to be heard along with the appeal. Full stop. Hence, Can 2 of 2025 shall be is directed to be heard along with the main appeal as and when the latter is taken up for hearing. Full stop. Affidavits, if any, shall be exchanged in the meantime regarding Can 2. Full stop. Next para. In view of the appearance of the respondent number 1 through its learned advocate, service of notice of the appeal on the respondent number 1 is dispensed with. Full stop. As mentioned earlier, since no relief has been claimed against the pro forma defendants, stroke respondent numbers 2 to 4, they did not contest also.
No, madam.
Nor did they contest in the trial court, service of notice of the appeal on the said respondents is also dispensed with.
Lordship,
the appeal be treated to be ready as regards service. Yes.
At the outset, I'll submit that we have not yet filed our wakalatnama. We have.
When can you file it?
Lordship, within a week, your lordship.
On the prayer of learned counsel for the respondent number 1, leave is granted to the learned advocate for the respondent number 1 to file his wakalatnama for the respondent number 1 within a week from date.
Lordship, another prima facie submission, your lordship. Lordship, the shares that which they are claiming, the 800 shares. Lordship, if your lordship compares 3 documents of the
We
supplementary
can't do that
affidavit.
at this stage. We are not granting injunction. If we granted injunction of stay, then definitely we would hear you out.
Okay,
We
lordship.
are not granting any relief to them. Only the expedition of the hearing of the appeal.
Lordship.
When the appeal is taken up, mention that.
Lordship.
Next para. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. Post up, the appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing. প্রথমে affidavit of service filed today.
Great.
Got instruction? Thank you. Got instruction? Oh, sorry.
From the learned counterpart below, there is details on, but the
ওইটা ওটা উল্টো দিচ্ছ, ওটা দাও বাঁহাতে। Yes.
But he is telling that her name was expunged, but more or less, as on today, she has died, and only the dependent number, respondent number.
Her name was
is the only
expunged,
legal words. And more or less, it will be expunged.
More or less expunged. How can you more or less? What will be more expunging? What will be less expunging?
He's
of the name will be expunged.
No, he's claiming that during the pendency of the suit, her name was expunged.
Your
due to
client
some
is
reason,
claiming.
not for death, but recently she has died. Recently, very recently, and no other legal heirs is there except the defendant number 1.
So you record your submission on that, on instruction you are submitting that, and will.
On instruction, but whether he was expunged below or not.
No, not expunging.
But
death, regarding the death.
Death, he is telling that he has died. And I will supply.
ওটা আগেরটা যা বলেছি তারপর থেকে।
And let an order be recorded that I will supply the death certificate.
On the on instruction, learned advocate appearing for the caveator stroke respondent number 1 submits that the respondent number 2, his mother, has died in the interregnum, leaving behind the respondent number 1 as her sole heir and legal representatives. Full stop. Next para. Accordingly, the learned advocate on record for the appellant is granted further leave to expunge the name of the respondent number 1 from the cause title of the memorandum of the appeal. Full stop. Next para. In view of the appearance of the respondent number 1 to caveat, the wakalatnama filed in connection with the caveat be treated to be appearance on behalf of the respondent in the appeal as well. Full stop. Hence, the appeal be treated to be ready as regards hearing. Full stop. The appellant, the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Leave is granted to the parties to mention the appeal for enlistment as and when the same is ready for hearing. If you find out, Mr. Shamanto, you ask for a copy of the death certificate from your client.
Record an order that I will supply in course of this.
No, I'm not. We are not recording that. But you take it from him. If he fails to furnish, do that. If he fails to do that, and if you find that she has not actually died, give notice to him, mention it so that we can recall our order and pass a fresh order. If she's alive, take wakalatna from her. That will take care of the situation, but we have to recall her order. Then we'll have to modify. No, if she has died, it's difficult to obtain the wakalatna. If she's alive, then obtain the wakalatna. But then we'll have to modify our order to that. Mention before us. Yes, next. This is 31. Yes.
Time for the appellant.
Yes.
This is my section 5 application.
What is the delay?
My lord, 450.
For the first time?
Yes, my lord.
The appellant shall serve a copy only on the on defendant numbers 1 to 3. Pro forma respondents, who are they? Co-plaintiffs?
Yes, no. They are also respondents, defendants only. They are pro forma defendants in the suit, but they are supporting me in this partition suit.
So service on them may be dispensed with.
Yes, my lord.
Very well. The appellant shall serve copies of Can 1 of 2025 along with Can 2 of 2025. Serve both.
Yes,
on the defendant stroke respondent numbers 1 to 3 and file an affidavit of service to that effect on the returnable date. Full stop. On the submission of learned counsel for the appellant that the pro forma respondents are supporting the cause of the appellant insofar as the present appeal is concerned, service of notice on the pro forma respondents is dispensed with. Full stop. Next para. The applications shall next be listed for hearing on February 9, 2026. Yes. Yes, Mr. Bhattacharya.
Plaintiff is the appellant.
You have to put up Tolaban and written up notice form. You have not done that, we'll grant you leave. Do that within a week. Tolaban and written up notice form. What is the matter about?
Matter not suit for
Deficit court fee also.
Yes, deficit also has been
put in.
Yes. Tolabana only
Tolabana will grant you leave.
Yes.
Yes. What is the matter?
Not suit for specific purpose of contract. Plaintiff is the appellant.
Why stay?
Stay not to transfer. I am the developer.
That will be injunction.
I am the developer.
You have then injunction should be filed. Injunction application should be
filed. Say
your caption is an application for stay. What is the prayer?
Prayer is injunction. Prayer is injunction.
So what is the ground in the appeal? Why was it dismissed?
Not maintainable.
Why not maintainable?
But because the nature of it not enforce the specific purpose of contract.
No, why? On what ground?
But your lordship can see and this page 47. The court will not enforce the specific performance of a contract under which one party is bound to continue duties, the due performance of which might require.
No, also on the ground of delay of 4 years.
Delay has been no, that finding has been in our favor.
Achha.
Only on that ground.
Let us see that.
And
no, what is the finding in your favor? Let us come to the internal page of the judgment. So specific performance.
Yes.
Page internal page 19.
The lordship can see page 46.
No, internal pages of the judgment. 19. We are at 19 only. Surprisingly, last paragraph. Surprisingly, the plaintiff.
No, that is delay ground. That is next paragraph. Your lordship can see page 20.
Achha. Which para?
Section 14B of the Specific Relief Act provides that the performance could not be
internal page which?
Second, third, fourth.
Section 14B, yes.
Fourth and fifth.
Restriction.
Yes. I am the developer.
No, Mr. Bhattacharya, you're wrong there. Page 19, last paragraph says, surprisingly, plaintiffs filed the suit after lapse of 4 years from date of execution. No cogent evidence why they filed the suit after lapse of such and such. Therefore, it can be safely presumed that the suit is barred in absence of any valuable evidence explaining the reason of delay, and thus execution of agreement and readiness and willingness on the part of the plaintiffs have little value. So, specific performance may be refused on the ground of mistake, miserable, and delay, even where these factors do not. And then 14B continuous. Then after that 14B paragraph, court will not enforce specific performance of a contract which one party is bound to continuous. That is a different ground.
Different ground.
Anyway.
The only thing, Lord, I am the developer. Development agreement. Everything has been completed. The plan has been sanctioned. I paid the money.
The present appeal has been filed against the dismissal of the plaintiff's appellant's suit for specific performance of a contract. Full stop, next para. But is this not, can a developer file a suit for specific performance? Anyway.
Here, Lordship, you can see page 11.
Yes, since the prima facie case has been made out, comma, the defendants stroke respondents and or their men and agents shall remain restrained by an order of injunction from selling, transferring, alienating, and or creating any third party interest in respect of the suit property in any manner till disposal of the application. Full stop, the appellant shall serve copies of Can 1 of 2025 and the memorandum of the appeal on the defendant stroke respondents indicating that the application shall be listed for hearing on February 9, 2026, when an affidavit of service to that effect shall be filed by the appellants. Full sub next para, the Tolobana and written up notice forms for effecting service of notice of the appeal on the respondent numbers 1 and 2 shall be deposited, comma, in terms of the order dated January 7, 2026 of the department, comma, within a week from date. Okay, thank you. Yes.
My lord.
Yes,
The
please.
appellant is out of court because of mother's illness.
Well, I'm for the
Health
number
is
one.
this week.
You are also in the matter record. You are also on record in the matter.
Madhumita Bhattu is on the record.
What is the matter about?
My lord, I'm for the respondent number one. I have no copy, my lord. I'm for the only for the filing Bhogalatma with the department. That's why I'm appearing, my lord. I have no copy, my lord.
Why only for 1? 1 to 4 appear together?
Well,
1 to 5.
I'm for appearing for the 1 and 2, my lord. Only for 1 and 2, my lord. Nitai Hal, Gaur Haldar and
Well, since an adjournment is sought, no, an adjournment is sought, an accommodation is paid for on behalf of the appellant. Full stop. Accordingly, let the matter stand adjourned and be listed next in the monthly list of February 2026.
Yes,
Next. Give your appearance, sir. Your appearance. You asked for time, so your name has to be on it.
34, my lord, I like to appear on behalf of the appellant.
Yes.
This is the first time I'm praying for application is for injunction, suit for partition, which has been dismissed.
Your partition should dismiss?
Yes.
Why?
Your lordship, I
You have
am
to prove
relying.
title.
No, I rely upon a earlier judgment passed by the trial court in a partition suit where the shares were declared. With regard to 1/7 share of, there were 7 heirs, each had 1/7 share. Now 2 of them died issueless. I say now there are five parts. Some of them have multiple heirs now, but the 5 parts remain, original 5 brothers and sisters. So now I say that jointly, all total, there are 1/5 share each. The learned trial court in the final portion records all this and finally says that there is no explanation as to how 1/7 share transformed into 1/5.
How?
Because 2 heirs, 2 brothers already died issueless. So that is why, if your
You
lordship.
have mentioned in your plan that 2 brothers died issueless.
Yes, yes, that is recorded in the trial court judgment.
Well, serve copy and come back, will grant injunction.
Yes.
The present appeal has been preferred against the dismissal of the plaintiff's suit for partition. Partition and consequential reliefs. Next para, upon perusal of the materials, we find a sufficiently strong prima facie case having been made out. So also, from the averments made in the injunction application, it is evident that unless injunction is granted at this stage, the appellants might suffer from irreparable injury. Next para, moreover, the balance of convenience and inconvenience is in favor of grant of injunction, since the matter arises out of a partition suit. Hence, the respondents.
I have prayed against 1 to 13.
Why?
The rest are they are the stranger purchasers. The rest are along with me.
No, stranger purchasers. As you are asking only restraining the.
One of the co-sharers has sold.
So they may not transfer to third parties.
I am saying that they are trying to enter into the suit property and change its nature.
1 to 13.
1 to 13.
You're trying to restrain them from fishing out. Fishing in, rather, in your problem.
Yes.
Catching fish, we won't disturb the present.
Because they do not have possession. This was a family property.
Catching fish, Mr. Chatterjee, without ensuring who is in possession, we won't.
We all along had injunction. If you ad interim as well as temporary injunction during
catching fish also.
No, not that restraint from entering into the property. Your lordship,
was that
ad interim page 21. Your lordship of the injunction application kindly sees. Page 22 is the ordering portion that the prayer of ad interim injunction is
1 to,
allowed.
1 to
One-
13 are strangers.
Yes,
Oh, they are the strangers.
they are the strangers. Are restrained from entering into the suit tank. That was the ad interim, and that was continued till the disposal. That was affirmed in page 26. Your lordship will find the temporary injunction was allowed.
Are restrained by an order of injunction from selling, transferring, alienating, and or encumbering the suit properties in any manner, and or from having any access to the suit property during the pendency of the injunction application. First, the appellant shall serve copies of Can 1 of 2025 as well as the memorandum of the appeal on the respondent numbers 1 to 13, indicating that the application shall next be listed for hearing on February 9, 2026, when an affidavit of service shall be filed to that effect. Full stop. Since no relief has been sought in the injunction application against the respondent numbers 14 to 20, comma, service of copies on the said respondents is dispensed with for the present.
I'm grateful, Your Lordship. And there is a already direction for depositing Tolobana. I'm praying for
Yes.
1 week.
The time for filing, time for depositing Tolobana and postal cost along with written up notice form is extended for a week from date.
I'm grateful, Your Lordship.
Your learned junior is very diligent. Yes.
Yes.
Item number 35.
Yes.
Lordship, I am on behalf of Lordship. I am behalf of appellant Lordship. I am submitting on virtual mode, Lordship.
My lord,
Yes,
Mr.
sir.
Arif Ali is appearing for the respondent, my lord. He is out of station today, my lord. I am praying for only not today. Lord, your lordship is fixed for final hearing of the appeal.
No, in view of appearance of respondent through advocate, we had dispensed with service of notice. But as per the CIS system and departmental record, no appearance has been filed either by Vakalatnama or in person. You have not filed your Vakalatnama?
Respondent, my lord. Yes,
Respondent.
Yes, my lord. We have filed, my lord.
You furnish the entry number of the filing, the filing number of the Vakalatnama on the next date and date. Slip is generally allotted to your clerk, will find that. So it will be, must be with him. So we used to tag with the brief itself, but it should be there somewhere. But give us the entry number and the filing date on the next day. On the prayer, Mr. Bondo, who is that?
Yes,
Mr.
Lordship.
Bondopadhyay?
Yes, Lordship. Yes,
Mr.
Lordship.
Bondopadhyay, they are praying for time. We are granting an adjournment to them.
Lordship, my
For the day, yes.
Okay,
The
Lordship.
prayer of the appellant, comma, the matter is adjourned for the day. Full stop. Next para, it transpires from the office report dated December 5, 2025, that no Vakalatnama on behalf of the respondent could be traced out in the department or from the CIS system. Full stop. Next para, accordingly, the learned advocate, you are for the respondent.
Respondent.
Acha, on the prayer of the respondent. Accordingly, the learned advocate for the respondent shall furnish the entry stroke filing number and the date of filing of the Vakalatnama on behalf of the respondent on the returnable date.
Much obliged, Lordship. Much obliged.
Thank you.
Item number 36.
I'm for the respondent.
I'm for the appellant, my lord. My lord, I am led by Mr. Budip Chatterjee. I am paying for not this week.
No.
Last to last time also time
No,
was paid.
sorry.
My lord, today one copy was served, and today
What copy
morning,
was?
today
What-
morning one copy was served.
What copy was served?
About 100, more than 100 pages. And he
Today morning?
Today morning.
Today,
Morning.
affidavit in opposition was served much earlier. We are relying on a valuation report that was only served, nothing else.
Nothing is that. That is 100 pages, more than 100 pages.
More than 100 pages.
We have craved leave to certain documents. Documents that has we will not rely on that. We will not rely on that. Let him place.
No,
We will
after
not
giving a
rely on
copy. Learned counsel for the
that.
appellant.
But will kindly appreciate that they are enjoying an interim order in respect of an eviction decree
If you
without.
serve a copy this morning, they are entitled to enjoy.
But the only thing we will not be relying on it because these were documents which were craved leave in the affidavit in opposition. We have given advance notice to
They
them.
were given an impression this morning that you rely on a document. You have given a copy to them. For that, their counsel is not there. The learned advocate is asking for time on that ground only. It will be betraying, the system will be betraying them if you insist on moving the matter without that. This is a fraud practice on the court, sir. You rely on, you give a copy to them. Their counsel knows that they will have to come prepared on that. On that ground, counsel is not here. Learned Junior is asking for time because you have given a 100-page document this morning. And when the matter is being moved, they're asking for time on that ground. You are saying I not rely on that, the junior should move. This is practicing fraud upon court. Sorry. We are very sorry to say this. Don't resort to these sharp practices. Learned counsel for an adjournment is sought on behalf of the appellant on the ground that document of more than 100 pages has been served on the appellant this morning by the respondents, giving the impression that the same will be relied on by the respondents at the time of hearing of the matter. On such ground, the learned advocate appearing for the appellant submits that his senior requires some more time to prepare himself. Next para, however, at the time of hearing learned counsel for the respondents submits that the respondents, if necessary, to expedite the matter, will not rely on the said document which has been handed over this morning to the appellant. Next para, however, since an impression has been given to the appellant by the respondents by handing over a copy of a thick document to the appellant, that the same will be relied on before the court, it will be a fraud practiced on the appellant by the system as well as by the respondents if the matter is taken up in the teeth of the adjournment prayer of the appellant. Next para, accordingly, the matter is adjourned till January 27, 2026. Next para, it is made clear that it will be open to the respondents either to rely on or not to rely on the documents handed over to the appellant today on the date of hearing, subject, of course, leave being granted by the court in the first place for the respondents to rely on such document, at the 11th hour. Next.
The only thing one kind
Please call on the next matter. Next বললেন, next ডাকবেন, বুঝে থাকবেন।
Item number 37.
Sir, give your appearance, please. Your appearance has to be given. Yes. Yes.
My lord, I don't know 37, my lord.
Yes.
My lord, I appear for the respondent.
It is my lord rejoinder. We have sharp copy on the set.
Yes.
This is my lord very short matter.
My exception application affidavit, my lord.
Exception to the reply. My lord, this is very short matter, my lord, your lordship. My lord,
Very short, you can see rejoinder to exception to rejoinder to reply to opposition. How long will this go on?
In respect of my lord alimony pendentiality.
Let us first find out the papers. So many rejoinders and exceptions and all.
Can one, my lord.
Can one, the opposition. Husband with opposition.
Can one, my lord?
Yes, please give us some time.
All right. Can one with ability to assess and liabilities are separately, my lord.
Yes, Mr. Dutt. It's a job.
List of
It's a appeal short. Yes. What is your current income, Mr. Datta?
I have explained my wife income in 46,000 an hour.
Para 19.
Paragraph 19.
You are for the wife, appellant.
For the wife. And my lord, I have stated that my husband.
What is your current income? That is what you asked.
My current income, my lord, I have stated in the evidences on also my application on paragraph 19.
What is that?
My lord, paragraph 19, you should find.
You don't know your current income. We are asking you, give the figure.
46,000 an hour.
Paragraph 18.
Paragraph 18, you also kindly find it out, my lord. 46,000, my lord.
You have a child?
I have a daughter, my lord.
What is the age?
My lord, 17 years of age. And he is, my lord, prosecuting a study, my lord, class 11, 12 science stream. And my lord, he is
11 or 12?
11.
Science stream.
And my lord, in a CBSE school, my lord, at Gurukul, my lord, at Bahrampur, my lord. and my
Yes.
and early I am getting my maintenance, my lord 5,000 for myself, and my lord 15,000 for my daughter by the order of the my lord, Sessions Court, my lord, in the 125 proceedings, my lord. I have mentioned in everything, my lord. Then, my lord, I have stated that my husband is a my lord working, is a senior staff consultant, my lord, and my lord also he is working, my lord, in a
Consultant in what branch?
my lord, consultancy, my lord,
He
software.
consults about what? Software. What is his declared income?
He's declared initially, he did.
No, lastly, what is his declared income?
10 lakhs per annum.
10 lakhs per annum.
2016 before this honorable court.
My lord, there is the evidence on the record, my lord, in the my lord, before the trial court, in respect of my alimony penalty, the matter went up to the Honorable High Court. The Honorable High Court, I enclosed the document that income tax return was placed, and that income was found by this Honorable Division Bench that his income during 10 lakhs.
Yes.
During income,
yes.
10 lakhs, my lord, but presently we have stated that I have stated that my husband is a blue card holder, but in the Netherlands, my lord, if a blue card holder, the criteria, the income not less than 6 lakhs per month, he's entitled to get the blue card.
But do we get that?
But I have enclosed, my lord. I have stated, my lord, they have not denied it, my lord.
Where have you stated?
My lord, your lordship will find that I have stated, my lord, your lordship kindly just 1 minute, my lord.
Yes, yes. That a blue card holder, to get a blue card holder, you have to earn minimum.
Yes. My lord, yes, my lord.
Yes.
Evident replicable করুন, evident replicable, এটা না, evident replicable করুন। Yes, my lord, I am placing my lord evident reply, you also will get it, my lord.
You have stated that the husband admitted before in his oral evidence that he earns rupees 7 lakh per month.
In the court below, my lord. My lord,
that evidence you have annexed?
Not. We have not annexed that evidence, my lord, in the my lord, interlocutory matter, my lord. That was the my lord, finding of the division bench.
You have stated that it is further ascertained that presently the husband is staying at Netherlands,
yes,
professional purpose as software, and he is earning a sum of rupees 7 lakh or more per month, as it is evident from the oral evidence of the husband respondent before the trial court as well as the jurisdictional magistrate. So where is that evidence? If he has admitted 7 lakh, we go by that.
10 lakhs for Kera.
You say in his oral evidence, it is evident from oral evidence. Instead of going in this roundabout fashion by inferring things that if someone holds a blue card, must earn 6 lakh.
I have stated in my application, also in my reply, also, my lord. I have stated, my lord.
Page 11.
Yes, magistrate's order is there. 125 order.
125, my lord. My lord, I have enclosed, my lord, the order passed by the judicial magistrate, my lord. My lord. Criminal division application, my lord, I have enclosed, my lord, page 31.
Got it.
Page 31.
Page 27.
মানে ও বলেছে যে 80,000 পার হাজবেন্ড পার মান্থ, ওয়াইফ বলেছে। মানে আবার 14 লাখ বলেছে ওয়াইফের অ্যালিগেশন। অ্যাডমিশনের কথা লেখা।
My lord, may I just answer your lordship's query, my lord, what I am earning? My lord, at present, my lord, I am not earning, my lord.
No, we'll come to you. For that, that's on merits. Yes.
Yes, because your lordship is looking for the order, my lord, that's why.
No, they say that there's an admission by you 7 lakh.
My lord, that is.
If you can find us that
No,
copy,
my
you
lord.
can.
Well, let him finish.
They have not also denied it, my lord. In their, my lord, affidavit, they also not denied, my lord.
You can't find the statement you are saying they have not denied. Where is your statement which they have not denied? That also you are not finding out, you are saying they have not denied.
Your lordship is perfectly
Let's
right.
see the statement first
Right,
that
your
you have stated. For a blue card or green card, whatever they have to.
My lord, I have stated. My lord,
then alimony matter, Mr. Dattu, we have to go by the facts.
Yes,
This is an entirely factual consideration.
My lord, page 11 of my reply, my lord, your lordship kindly consider it. In my reply, my lord, I have specifically, my lord, I have heard everything, my lord, your lordship.
Page 18,
My lord, in can, my lord, paragraph at page 8, he has said this, he has made this statement that I'm earning rupees 6 lakhs.
Take a seat. Yes.
My lord, regarding the allegations as contained in paragraph.
In reply, you have stated. How can they further?
No.
In the main application, you have not stated.
I have also stated, my lord, paragraph 8 onwards, your lordship will find.
No. In reply for the first time, you say that.
When they disclose that he is a, my lord, citizen, permanent citizen of my Dutch citizen, he have obtained the Dutch citizen.
Yes.
Dutch citizen, my lord. Then we in the reply, initially I stated that he is a blue card holder. Then as per criteria of the blue card holder, my lord, below 6 lakhs is not.
If initially you knew that he was a blue card holder, you should have stated in your application itself that
application
earns more than 7 lakh per month.
My lord, application we have enclosed the document that is the regarding his blue card holder to
show us that document.
My lord, page 17 you will find.
17 of?
17 of my lord, application, my lord, PP1, my lord, this is my lord, his status he has mentioned. From the from your website, my lord, we have downloaded.
Website is a sort of advertisement.
From his personal.
Website is an advertisement.
He has not denied it, my lord.
From his own profile.
Own profile, my lord.
The profiles, it's always exaggerated. I mean, it's settled in several judgments also it has been held, Mr. Dattu.
But
that in these website profiles, LinkedIn profiles, professional profiles, one may have some amount of element of advertisement.
But
that is not a foolproof proof of their.
But we have stated on oath, they have not denied it, my lord.
Where will they deny? In a reply, go and state.
No.
In the step application, you have not
application we have stated that he is a blue card holder and he is earning more than 6 lakhs. This is the criteria of the blue card holder.
Achha, let us see your application and their objection.
Just, my lord, I am reading this application. We will fine.
Yes, page 17, they have not stated they are a blue card holder or they earn more than 6 lakh. Where have they stated that?
My lord,
here they say the lead consultant working on different role, support implementation.
my lord, your lordship find paragraph 11.
Of the application.
In my application, my lord. Paragraph 11, that your petitioner says that in 2012, the petitioner filed an application under section 36 of the Special Marriage Act, maintenance alimony penitentiary and also for maintenance for minor daughter, such and such. My lord, next, my lord, it is pertinent to mention that in the said petition of maintenance penitentiary, the petitioner specifically stated that respondent husband was a computer engineer, SAP consultant and IBM, and initially, my lord, such and such.
Yes,
then, my lord,
you don't know where you have stated in a last paragraph of page 8, my learned brother found out.
Yes, my lord.
Let us see how they dealt with this paragraph in there.
Paragraph 8, my lord, your lordship will find.
The reply that.
In opposition, my lord, your lordship, there is evasive denial, your lordship will find.
Paragraph 9 deals with paragraph 8.
Paragraph 9, my lord, your lordship. This is, my lord, evasive denial, my lord.
They have also denied that they are a blue card holder.
They are now saying that they are the citizen of Dutch citizen, my lord. Dutch citizen, my lord. They are now saying, they are not denying that the originally he was a blue card holder, but he is saying that presently he is a Dutch citizen, my lord.
For becoming a Dutch citizen, you have to have a blue
But
card.
I have enclosed the criteria, my lord. In my reply, you will
are wanting that only. Where are the criteria? Show us.
Yes, my lord. Yes, lordship, kindly go through my reply, my lord. Your lordship will get the answer, my lord.
You went to a reply, you did not find the answer because you did not tell us the page number.
Disclosed in the evident opposition, my lord.
Where do we find that to hold a blue card, you have to have an income of 6 lakh? From which document? Show us any document. We cannot go on presumptions, Mr. Dattu.
No, my lord.
We have to have some document to show, know that for holding a blue card, one has to have 6 lakh income. We don't even know the exchange rate of that Dutch currency, whatever that is. I don't know the name of the currency also.
Deutschmark.
Deutschmark. Deutschmark is German.
Deutsch, German, Dutch.
Oh, now it should be euro. Euro. Yes, yes, right.
And one.
Deutschmark, Germany.
And 1 euro is equal to 1.
Should be euro then.
1 euro is equal to 1.
Exchange rate of euro, you regularly go there. So
105 rupees, my lord.
My lord, roughly 105.
105. 1 euro is equal to 105.
You have your conferences there.
No, my lord, unfortunately.
Pound is there. I don't know.
Euro is something like it's running 90, 99 something.
Thank you. Mr. Datta, come prepared. This will take the whole day unnecessarily. With specific paragraphs where you have alleged, they have stated, and let us decide.
On 27, your lordship.
My lord, may I just very quickly respond to the queries that fell from your lordship? My lord, then perhaps.
Come back on 27th, they are not ready in the matter.
Well, my lord, at least we'll kindly look into the amount of money that they're earning per month.
Have you directed any interim amount?
Ad hoc 1 lakh rupees, your lordship.
Lord, may I respond?
1 lakh has been adjusted already.
My lord, may I respond to that?
No, don't respond. Let him first argue, then you respond.
Well, to your lordship's query whether I'm paying any money.
We will forget that on the next.
I'm extremely sorry, my lord.
Learned counsel for the appellants is granted an adjournment on his prayer to get fully prepared in the matter. Husab, let the matter stand over till January 27, 2026. On that date, we will positively decide the matter.
Yes.
Whether you are ready or not. We'll give 15 minutes to each side, Mr. Dattu. We are making it very clear. 15 minutes on alimony application, 15 minutes is sufficient.
15 minutes
15 to you, 15 to your learned friend, and we'll discuss.
My lord, only one request may I make? My lord.
15 minutes to each of you and 15 days for us to decide.
All right.
Yes.
My lord, only one request. My lord, may it just retain its position on 27th. Because, my lord, on 28th, my lord, I will not be able to attend.
No, if you are not able, we will not take up the matter. You have been consistently appearing in the matter.
So great.
Yes, এটা একটু ঢুকিয়ে দাও তো ওখানে বলো এর মধ্যে ঢুকিয়ে দাও এটা একটা দ্যাটস
I'm so grateful.
হ্যাঁ হ্যাঁ
বলবো
কি করে রাখো কোশ্চেন করে রাখো আপনি
Well, I have got a petition.
Yes,
Appellant petitioner.
First, let us ascertain the defects. You are just to name the learned civil judge, the trial judge. Name of the trial judge has to be given in the preamble of the appeal. Do you know the name? Can you do it during the course of the day?
In course of the day.
Course of the day. We'll grant you that leave and take up the matter. একটা লাইন লিখে নিন, লিভ ইজ গ্রান্টেড টু দ্য লার্নেড অ্যাডভোকেট অন রেকর্ড ফর দি অ্যাপেলেন্টস টু ইনসার্ট দ্য নেম অফ দি learned trial judge in the preamble of the memorandum of appeal during the course of the day. Please, yes. What is it?
Well, Lord, this is my application to direct concerned department to bring the learned trial course record by special
What
messenger.
is the appeal against?
Appeal against death declaration, shoot for death declaration.
That has been dismissed.
Yes, my lord. In the maintainability point.
Why not maintainable? According
My
to
lord, kindly see the judgment impugned order dated 23.
They have not denied.
As the state was not denied the death, thus the relied on a decision.
Yes, Justice Nagar.
The writ petition, the learned trial court below dismiss the suit.
Oh, says no cause of action.
No cause of action.
What cause of action have you stated in your plaint?
Yes, my lord.
Let us see.
In application, the plaintiff's predecessor, Nitai Charan Rokhit, missing since 36/2016, my lord. Page 8.
Any missing diary?
Yes, yes, my lord. All are there.
That missing diary is later, of a later date or contemporaneous?
No, contemporary.
Contemporary.
Paper publication also
Oh,
there.
yes, yes. So to 2016 you have done it.
19/9/2016, missing diary was lost. On 2/7/2016, your petitioner lost a missing report before the opposite party number.
You are his son.
I am the son, wife, and near
Immediate
Gopal
son.
Rokhit is the son.
Right.
Dolly Rokhit is the wife, and Priyanko Rokhit is the son of the
Yes.
missing
Why?
person.
Why refuse? Let us. দেখি কেন করেছিল। This judgment was cited by any of the parties?
No, my lord.
The court of his own cited?
Yes, my lord.
এটা কিন্তু ঠিক ইয়ে নয়।
Which was a writ petition, my lord, passed by his lordship. The lordship DK set.
Have you got a copy of that judgment?
No, my lord. I had.
Should have brought that. We could have decided this right now, subject to consent of Mr. Dev.
No, I have nothing to say.
Obviously, you are a neutral. The state has to be neutral here. Please take your seat, Mr. Dev. We'll just look into this because the relevant portion has been quoted here.
সরকারি ডিসপ্লে করে দেবেন যাচ্ছে। খুব প্রণব চট্টোপাধ্যায়ের ঘরে জহরটা আমার আগে আমি আর জহরটা একসাথে লিখে দিতে হবে সুপ্রতিম সুস্থ।
জাজমেন্টটা দেখতে হবে। হ্যাঁ শুধু ডিক্লারেশন চাইতে পারলাম না, তারপর তো ফলো পুরো সবকিছু ডিক্লেয়ার বার্ডেন অফ প্রুফটা উল্টে দিয়েছে। এখানে যেটা বলতে চাইছি সেকশন 34 ডিক্লারেশন হবে না, কারণ কোনো লিগাল স্ট্যাটাসের ডিক্লারেশন নয় এটা। একটু স্পেসিফিক রিলিফ একটা দিন তো। See, that judgment practically what was held was that you are entitled to seek a declaration regarding your legal character. You have to have a personal interest. Now you have only sought decree of declaration of civil death without any consequential relief, such as your declaration that you are the joint owners of the property or something like that. Only civil death of a person, because language of section 34 specifically fact is may institute a suit his title to such character or right. So you have not sought any declaration regarding your title to any character or right. And Civil Procedure Code section 9 says right to property or to an office can be asked for. So you have claimed for neither. You have sought that that person has died.
Decree for declaration of civil death of Nitai Sharon
Do
Rocky.
this. You file a one-page amendment application to the plaintiff before us. We'll allow that amendment application. You seek your declaration also, declaration of title and consequential relief. Any consequential relief, file a two-page amendment application.
For provision of section 108 of the Indian Evidence Act.
No, there is no such provision. 108 does not give you a part that cited judgment is right in a sense that simply stated death, declaration of a death of a person is not permitted under section 108 or section.
Amendment.
Seek your title, declaration of your title consequentially B or A1. We need not, then we have to dictate the amendment application. File an amendment application on your pair, we are saying we're adjourning for a fortnight. We'll keep it after a fortnight. In the meantime, file the amendment application, give a copy to Mr. Des Junior, and just mention that application so that we can, on the pair of the appellant, comma, leave is granted to the appellant to file an application for amendment to the plaint and mention the same to be tagged along with the present application. Full stop. Next para. Let the matter be adjourned till February 9, 2026, when it will be listed under the same heading, along with the connected amendment application, comma, if any filed in the meantime. File that amendment application with Mr. De's consent. Will take up the appeal and the application together and dispose of everything.
I am grateful to your
Affidavit size filed to be kept.
Supratim Dasgupta, landed third bench judge.
No, you have to incorporate that in the memorandum. Do it right now. A1. Consequence লিখতে হবে না। এইসব সুট ফালতু কারণে পড়ে আছে। ডিক্লারেশন চাইলে সমস্যা দিয়ে দেবে, স্টেট অপোজ করছে না, এখান থেকে রিভিউ দিয়ে দেওয়া যেতে যদি।
Yes. In this matter, my lord, your lordship heard the matter, my lord, on the previous occasion. Our case is that
appeal along with the application. Yes.
Our case is that, my lord, the father of the defendant number.
Chakraborty, please take the microphone a bit closer.
My lord, our case is, my lord, father of the defendant number 1.
You are the defendant or the plaintiff?
I am the plaintiff. My lord, I filed the suit. My lord, my case is that I am a Thika tenant and defendant number one's father was a tenant, Bharatiya under me, and defendant number one's father died.
Oh, transferring assignee.
Yes, yes, my lord, he is trying to.
So it was dismissed on the ground of section 34.
Only
Proviso.
34. Only 34.
Yes, what do you say?
My lord,
I need not ask for eviction. I mean,
no, my lord, this is not a case like that. My
not a
lord.
case like that.
I will show the first. I'll show the original plaint. My lord. Kindly takes up the original plaint.
Plaint is not annexed, Mr. Chakravarti?
Plaint is there.
The amended plaint has been annexed. The original one has not been.
Achha.
Lord, kindly.
Original plaint, why should you look into the original plaint?
Why,
Amended plaint?
Milord, kindly sees the prayers in the original plaint. Was they have completely modified the prayers and their cause of action.
That amendment was allowed.
That was allowed. Their original case was that if their case would have been that other defendant number one in the suit is a tenant, then my case would have been extremely weakened. But their case is all along has been that I am an illegal occupier and I have no right title interest in the suit.
If the amendment has been allowed, that has not been challenged, then this stage is over. We cannot look into this.
Milord,
we have to look into the amendment plaint only.
Milord,
when the amendment has been allowed.
No, what changes has been made, Milord? I am only indicating to that extent.
You have not preferred any challenge to the amendment
no,
application.
Milord.
You cannot reopen that.
After
that has been passed by a competent court.
Yes,
It's
Milord.
now an amended plaint. Amendment goes back to the date of the suit unless otherwise said in the order.
Yes, Milord. Milord,
Date of filing of the suit.
kindly takes up the amended plaint then.
Degree
Even
for
from the amended plaint, Milord, I will try to demonstrate that the suit is barred under section 34, Milord.
No right to transfer sublet, that was there, but they also sought for eviction there.
They also sought for eviction, Milord, of both the parties.
Now they have taken out eviction.
Now
one can relinquish a part of their
Yes,
claim.
Milord. They can, Milord.
Yes, page 21.
Yes, Milord. In the prayer, Milord.
This is the amended plaint, page 21.
Page 20.
Oh.
Bharatiya Thika tenant is, you have not written so many words.
In no
you are
way,
saying that they are an occupier.
Well, we have stated
way,
that I am a Thika tenant. I am a Thika tenant. My lord,
They are an occupier. There may be a license.
difficulty, my lord, if the tenancy is a Thika tenancy, civil court jurisdiction is ousted. That's why I cannot pray for eviction in the civil court. So that's why injunction is the only, my lord, appropriate relief that has been prayed for. And my friend, my lord, he is defendant number 2, who is my lord, anticipated subtenant. He is anticipated subtenant, my lord. He has not adduced evidence in the court below, and the defendant number 1 has also not adduced evidence in the court below. My lord, he is trying to trespass into the suit property, having no legal right over the suit property. My lord, let him, my lord, explain how he is contesting, what is his status there.
Milord, kindly takes up the prayer.
Totally misnomer.
Of the amended
So let him satisfy us on 34, because
Yes,
even if you allow your appeal, Mr.
Yes.
Chakravarti, you have to send it
Yes,
back for consideration on merits. Yes.
Milord, prayer B states the first prayer is like your lordship had already
Occupier
noted.
after death of tenant.
Yes, as an occupier.
Yes.
They are stating that is
Whatever.
Milord, that occupier.
Why is the suit barred by proviso?
Yes. In the prayer B, they are stating that decree for declaration that the defendant number 1 being an occupier have no right to transfer sublet, hand over the suit room to the defendant number 2 without written consent of the plaintiff. That they are stating.
Sufficient.
And in the permanent injunction, similar prayer they have stated, Milord.
That is sufficient for maintaining a suit.
Now, Milord, kindly takes up my written statement once.
We cannot look into written statement for this purpose, because that will be adjudication on the merits. Whether a suit is barred by section 34 proviso can only be ascertained by looking into the plaint and only the plaint reliefs. Nothing else. Only the plaint reliefs.
Milord, but that after that is
the only ground on which it has been dismissed.
Only ground it has been
We'll
dismissed.
set it aside and remand it to be heard on merits.
Milord, here.
How is it barred under which relief being
section-
able to seek they have not sought? Eviction, it's his choice not to evict you. It's
Milord,
not a necessary relief.
If I'll just indicate, Milord. Section 34 states any person entitled to any legal character or to any right as to any property.
We know what it says. What
Yes,
is your
Milord.
ground?
Milord, he is neither seeking a declaration as to any legal character
He is neither seeking any right to any property. What is his declaration? That I am an occupier. He is not stating I am a tenant, because if he states that, the suit itself would be barred before the civil court. That declaration the civil court cannot give, my lord, under the Tika Tenancy Act. That is why, in the couch of this declaration, he is seeking that I am an occupier, which itself is an indeterminate right. It does not. It's an inchoate, my lord. It's an indeterminate right. He has to specify what sort of an occupation I am in, my lord. Thereafter, in the permanent injunction prayer, my lord, what from the record it will reveal, they had filed they had a status quo order in their favor throughout the suit, my lord. They had filed an order 39 rule 3 rule 2 application complaining of violation of the injunction order.
Go and take that point that is barred by the Tenancy Act. The suit has been filed.
Trying
avoid the rigor of
trying to
but just one
I am
thing, my lord,
on that ground, if it was dismissed, we could have understood a very arguable case has been made out.
their further relief is of recovery of possession, since they are not
Not
admitting my since they are not admitting my status, my
No,
lord.
definitely not. I may seek a restraint on my tenant or my occupier, even a licensee, so that he does not transfer to a third party.
In these three cases, he may, my lord. But once he says that I am an illegal occupier,
He had not said illegal occupier. He has said you were the occupier of the suit room after the death of original tenant.
My lord, he has stated, kindly sees
We
that.
read from the plaint.
Yes, from the plaint. Dictate for declaration. Yes, he's stating that I am a occupier and I have no right to sublet. They have, at the time of arguments, my lord, they have sought to incorporate this prayer for recovery of possession. I need to show that Order 6 Rule 17 application, where they sought to incorporate a prayer for recovery of possession from both the defendants, and they not press that particular application as well.
Their choice.
My lord, they
Their
admit
choice.
this fact, my lord, that
Why not praise? They initially filed a suit for recovery of possession.
this is the second amendment, my lord. The second amendment they had.
We have to see the last amended plaint when the judgment is passed by the court.
Yes, but Miller, in the proceeding, but kindly just seize this amendment application once. Kindly, Miller.
Their original suit says that their original suit contained a prayer for recovery of possession.
Yes, claiming that I have no right title interest. At that point of, he is claiming that I have no right title interest, my lord. Thereafter, he takes away the prayer for recovery of possession and brings in a declaration that I am an occupier. So he recognizes some sort of status of the defendant number 1, my lord.
So what? Why is the suit barred under section 34?
Because thereafter they filed a order 39 rule 2A application where they specifically admit this
Even
fact.
if that is so, whatever they admitted there, how is the suit barred by the proviso to section 34?
Because the
what further relief they must
of
have...
recovery of possession.
No, that's not necessary.
Because we are
yeah, enough. Please don't repeat on and on and on. Heard learned counsel for the parties. Full as per our previous direction, the appeal is taken up for hearing along with the application. Full the conspectus of the appeal is short. Full the learned trial judge dismissed the suit filed by the plaintiff, inter alia for declaration that the defendant / respondent number 1 is an occupier of the suit room after the death of the original tenant, and for further declaration that the occupier has no right to transfer, sublet, and or hand over the suit room to the defendant, শুরু করলাম কি দিয়ে না তারপর and for permanent injunction to that effect. Push up next para. The only premise on which the learned trial judge dismissed the suit was that it was hit by the proviso to section 34 of the Specific Relief Act, since the relief of recovery of possession, which according to the trial court, is the further relief which the plaintiffs must mandatorily pray for, was not sought. Full stop. Next para. The learned advocate appearing for the plaintiff / appellant submits that it is the choice of the plaintiffs as to whether or not to seek recovery of possession of an occupant / tenant of the premises. Full stop. Next para. It is submitted that since the plaintiffs claim to be tika tenants of the property, the relief of recovery of possession is not maintainable before a civil court, and comma in any event comma such relief has not been sought by the plaintiffs. Full stop. It is submitted comma however comma that the relief of declaration and the relief of permanent injunction consequential thereto were sufficient to satisfy section 34 of the Specific Relief Act 1963. Full stop. Next para, learned counsel appearing for the defendant stroke respondent number
2.
Only for 2?
Yes, my lord, only for 2.
Defendants you have served on 1.
My lord, no,
আমি ডিফেন্ডার নাম্বার 2 এর
my lord, service হয়েছে? No, true, I'm not sure, my lord. My lord, in the trial court, my lord, he filed the written statement, but thereafter did not pursue, my lord. My friend was there for both.
How can it be for both?
My lord.
One is transferring to them, you have alleged.
No, yes, my he has, he was
The defendants jointly had filed a
joint written statement on behalf of defendant 1 and 2. And thereafter did not adduce evidence and
You are directed to file an affidavit of service on a previous occasion.
Defendant number 2 এর উপর সার্ভিসটা কিভাবে হয়েছে? 1 এর উপর?
You also directly file paper books in fact.
হ্যাঁ?
You have filed affidavits. Two submits that the plaint, comma, as it originally stood, comma, contained a decree for recovery of khas possession from the suit room. Full stop. It is submitted that a sea change has been brought about in the reliefs by omitting the prayer for recovery of khas possession and introducing a vague relief by way of declaration. Full stop. Next para. It is submitted that the trappings of section 34 of the Specific Relief Act 1963 are not satisfied, comma, since relief small a within bracket of the plaint is a vague relief, comma, not directly pertaining to the title or character or right of the plaintiff in respect of the immovable property. Full stop. Next para. Learned counsel for the respondent number 2 further seeks to rely on the averments made by the appellant, by the plaintiff stroke appellants in their injunction application in the trial court in support of his contention that the relief sought in the plaint is vague. First up, it is sought to be reiterated by learned counsel for the respondent number 2 that in the conspectus of the allegations made in the plaint and keeping in view the original prayers of the plaint, comma, the relief of recovery of possession is a mandatory adjunct to the other reliefs sought by the plaintiffs. Full stop. As such, comma, learned counsel submits that the learned trial judge was justified in dismissing the suit due to violation of the proviso to section 34 of the Specific Relief Act 1963. You want to add anything to this?
My lord, only one thing. They have admitted the fact that both the defendants are in possession as an illegal occupier.
No,
They have
trying
admitted
to, no,
everywhere.
trying to.
Where have they admitted?
No, I have never.
My lord, plaintiff they have not admitted.
In the
plaint they have not
they admitted. Then after in the order 39 rule 3 2A application, my lord, they are specifically admitted they broke open the padlock and they have entered into the suit property.
Very learned counsel for the defendant stroke respondent number 2 further submits that in the original plaint as well as the interlocutory applications filed in the suit, comma, the plaintiffs admitted that both the defendants are in occupation of the property. Full stop. In the light of such admissions, comma, it is submitted that the suit would be bad for non-inclusion of the relief of recovery of possession. Full stop. Next para. Learned counsel for the appellants denies the last aforementioned contention of the respondent number 2. Full stop. Next para. We find from the upon hearing learned counsel for the parties, comma, we find from the impugned judgment that it was recorded by the learned trial judge that the plaintiffs have not made any prayer for recovery of recovery of khas possession, and that it appeared from the records that at the stage of argument they tried to insert such prayer by way of an amendment, but it was ultimately not pressed by the plaintiffs. Full stop. On such premise alone, the learned trial judge proceeded to observe that it is clear that the plaintiffs themselves admit that the suit is bad, as no prayer for recovery of possession has been sought for. Full stop. Next para. In the light of the said observation, the learned trial judge drew an inference that the suit was barred under the proviso to Section 34 of the Specific Relief Act 1963 as a relief of recovery of possession is a further relief which the plaintiffs must mandatorily pray before the court, since the plaintiffs are admittedly out of possession. Full stop. Next para. The learned trial judge also placed reliance on a judgment of page 19 impugned judgment এর না আছে এটা আমি সাইটেশনটা বলে দিচ্ছি quoted at 2014-14 SCC 502, where it was held that a suit for declaration of title over suit land filed without claiming consequential relief of possession by eviction of tenants in possession of the suit land was not maintainable. Full stop. The fact that the plaintiff could later file a suit for eviction of tenants is no ground to hold that the suit is maintainable. Full stop. Next para. It was further observed that permitting the appellant to maintain the suit would also defeat Order 2, Rule 2 of the Code of Civil Procedure. Full stop. Next para. In the present case, however, we find from the averments made in the plaint that the cause of action for the suit arose when the defendant number 1 illegally sought to transfer and hand over and stroke or sublet the suit property to the defendant stroke respondent number 2. Full stop. Next para. The very premise of the cause of action, as disclosed in the suit indicates that the plaintiffs are not bent upon having khas possession of the property, but merely seek further transfer of the property by the defendant stroke respondent number 1 in favor of the defendant stroke respondent number 2. Full stop. Next para. Thus, the fabric of the suit does not necessarily mandate that recovery of possession ought to have been sought by the plaintiffs. Full stop. Next para. It is well settled that a judgment is a precedent for only what it decides in the facts and circumstances of the case, and not for any derivative or corollary of such proposition laid down in the judgment, which can be inferred secondarily from the said ratio. Full stop. Next para. Proceeding from such perspective, the judgment of the Supreme Court relied on by the learned trial judge is not apt in the circumstances of the case. Full stop. In the present case, the plaintiffs have not merely claimed declaration of title over the suit property, but have specifically sought declaration that the defendant number 1 is the occupier of the suit room after the death of the original tenant, one Ram Pandey, in the suit premises, the corollary relief, the secondary relief of declaration that defendant number 1, being the occupier, has no right to transfer, sublet and or hand over suit room to the defendant number 2, and the consequential relief of permanent injunction restraining the defendant number 1 from doing so. Full stop. Next para. Thus, in the facts of the case, the relief of permanent injunction would suffice to complete the nature of relief sought in the suit. Full stop. Next para. Hence, the proviso to Section 34 cannot be attracted in the present case. Full stop. Next para. For the sake of convenience, the prayer portion of the plaint is set out here in below. Page 21 থেকে 22. Here in below. Next para. In such context, comma, we cannot agree with the observation of the learned trial judge that the relief of recovery of possession was a mandatory relief to be sought by the plaintiffs in the present suit as framed. For some next para, the mere fact that the plaintiffs, comma, during pendency of the suit, comma, also made an application seeking to introduce the relief of recovery of possession, but later not pressed the same, and stroke or the relief of recovery of possession was originally a part of the plaint but subsequently amended, comma, do not have any german bearing on the outcome of the suit. For sub next para, within the contemplation of order 2 of the code of civil procedure, comma, it is in any event open to the plaintiffs to relinquish a part of the claim made originally in the suit. Full stop. Next para. In the present case, comma, the relief of recovery of possession is not so essential that omission of the same shall render the suit barred under the proviso to section 34, which stipulates that no court shall make any such declaration where the plaintiff, comma, being able to seek further relief than a mere declaration of title, comma, omits to do so. Full stop. As discussed earlier, comma, the relief of permanent injunction takes care of the cause of action of the suit, comma, as per the frame of the present suit. Full stop. Next para. Accordingly, comma, FA 393 of 2025 is allowed on contest, comma, thereby setting aside the impugned judgment and decree dated August 27, 2025, passed by the learned judge, second bench, City Civil Court at Calcutta, District Calcutta, in title suit number 708 of 2012, and remanding the matter to the learned trial judge for a fresh adjudication of the suit on merits, comma, on merits upon giving adequate opportunity of hearing to both sides in accordance with law. For some next para, it is made clear that apart from setting aside the impugned judgment on the ground of maintainability of the suit, comma, this court has not entered into the merits of the respective contentions of the parties in any manner whatsoever, and it will be open to the learned trial judge to decide all questions on merits in accordance with law, independently, comma, without being influenced in any manner by any of the observations made above. Can such and such is also can one.
May I ask for status quo?
Can 1 of 2025 is accordingly disposed of as well. No, we have disposed of the appeal. We are not in season of the matter.
Grateful, Mr.
Thank you. Sorry, but you argued very well, but we can't help you in this case. Later on, when you take the ticket tendency point and Mr. Chakraborty wins that, then we'll have a better.
Grateful. Thank Defendant respondent.
One.
This is a application, my lord.
Tolovana not deposited, but you are appearing.
I was on KB.
So no question of Tolovana. Yes.
My lord, the order 7 rule 11 application has been allowed. I am the father of the, my lord, before the trial court, father of the plaintiff. My lord, the gift deed has been prepared in the year of 2006.
Suit has been allowed.
Suit has been, my lord, dismissed by the order 7 rule 11 has been allowed.
You are the father of the.
I am the father of the plaintiff before the court below. I filed that, my lord, the suit before the trial court, my lord, that they have been asking for cancellation of the deed.
Plaintiff is a minor.
Plaintiff is the major.
Father
Father of the plaintiff filed the suit means?
The father and the as if my status is father. I am the plaintiff
Father
before
of
the
the
plaintiff.
defendant. My father, my lord, have filed a suit against me, my lord, seeking cancellation of a particular deed. No, that is the case.
He's the father, you're the father.
I'm the father.
The suit has been dismissed.
Suit has been dismissed.
Why? Son was influential.
So, son has been misleading me. deed of gift has been
Why was it dismissed?
On the ground of limitation, and another points they have been stated in the suppression. But the limitation point, my lord, kindly goes to the copy of the plaint in the year of 2022, when I came to the knowledge from the certified copy from the department that the deed has been executed from the ADSR Asansol.
Your cases of misrepresentation, you signed something else.
Something else, my lord.
You are made to understand it. You are signing something else.
Something else, my lord. By the threat of dispossession, thereafter I filed the title suit before the court below. And thereafter, the land trial court, the dismissing the suit that the 2006 and 2022 have been filed as a long lapse of limitation. On that ground, they have been, rejected the copy of the plaint. And this, the ground also.
Previous suit.
There is no other suit. They have been taking the suppression. Then is another lease deed has been executed in the other land, other portion of the land, not the RS Khotian number which has been appended to the copy of the plaint. There is a separate Khotian. Though, my lord, the learned trial court asking me that this is a suppression of fact, you have not stated about the lease deed or other thing. But kindly come to the copy of the plaint. That is the page, my lord, the page 14, paragraph 8, starts from page 14, paragraph 8. Copy of the plaint. That all on a sudden, 24th February 2022, the defendant and member-in-law's family, accompanied with some antisocial elements, came to the suit property and directed the plaintiff and family members to quit and vacate the suit property, and claimed that the defendant became the owner of the suit property. As the plaintiff executed the deed of gift in favor of the defendant,
plaint has been rejected.
Plaint has been rejected. And thereafter, my lord, the paragraph 9, the plaintiff has a younger son, daughter, son-in-law protected towards the fraudulent acts of the defendant, and thereafter the defendant complained to leave the house of the plaintiff on 9th March 2022. Again, the some member-in-laws of the family of the defendant, along with the some antisocial element, tried to evict the plaintiff, members of his family, forcefully from the suit property. However, such unlawful and wrongful effort was anyhow resisted by timely interference of the plaintiff and his well-wishers, and that the plaintiff has rushed to the office of the additional district sub-registrar Raniganj and took the certified copy of the alleged deed of gift on 25th March 2021, being the deed of gift number such and such, the ADSR Raiganj. The defendant has obtained the purported deed of gift number such as additional district sub-registrar Raiganj absolutely by practicing fraud upon the plaintiff and by misusing the trust reposed upon him by the plaintiff, and the defendant obtained the fraudulent representation, and thereby the deed is void. And purported deed of being on such and such executed and registered before the additional district sub-registrar Raiganj and referred to as the said deed. Plaintiff has never executed any deed of gift out of any love and affection, nor has any plaintiff any reason thereof. Moreover, the plaintiff, his family, has no other place to reside in the separate house, being the owner thereto, nor he was voluntarily gifted the suit property out of the aforesaid consideration of love and affection. It is stated that defendant obtained the said deed of gift number such and such by practicing fraud and misrepresentation upon the plaintiff, and thus the said deed of gift is void ab initio. The save annexed the suit property of the plaintiff has no place of residence of himself and his wife, he has constructed from his hard and earned money and enjoyed for personal benefits, and aforesaid defendant and their henchmen being pulled up with the last stand out of their greed and from some illegal gain, and had hatched up a conspiracy for grabbing of the suit property by any means. Accordingly, they have been succeeded in their illegal plan by executing a registered deed of gift in favor of the defendant January 2026 by practicing fraud and misrepresentation, undue influence upon the plaintiff. That the plaintiff, after getting the certified copy of the said deed, requested to defendant to cancel the same, but the defendant refused to do so, hence the suit. The plaintiff apprehends a serious injury towards the outstanding of the said deed of gift, culminating in the instant suit. The deposit deed of gift being number such and such, office of the ADSR Raiganj is void ab initio, non-est, and not binding upon the plaintiff, and same is liable to be cancelled. Cause of action of the present suit arose on and from by 22/2/2022. The plaintiff for the first time came to know the defendant fraudulently obtained the said deed of gift, and thereafter on 25/3/2022, when the plaintiff got the certified copy, and day to day thereafter within the jurisdiction of this court as well as where the suit property situates. Both the purpose of the court fees and jurisdiction of the court is valued of rupees 20 lakhs, permanent is valued of 100, and the plaintiff for the adjourned court fees thereon. This is, my lord, the And also the declaration be passed declaring the aforesaid deed of gift such and such in the year 2006 of the office of the AGSR Asansol is void.
What about the lease deed? What lease deed?
Lease deed, my lord, regarding the another one portion of the land, that is, my lord, the separate Khotian number described in the schedule of not matching with this small property. This is my
You said that this gift deed, an impression was given to you that you were executing a lease deed. And that was subsequently you lived in Maharashtra. You came back subsequently, all on a sudden on 24th February, this disturbance, they disclosed the deed of gift, and then you came to know. So therefore, you said it is not barred by limitation. And what lease deed you don't understand even? It was there in their Order 7 Rule 11 application.
No, no, there is no Order 7. That kindly see the Order 7 Rule 11 application. They come to page.
So where does it come to? What does the court get this lease deed about?
Nothing, they have been expressed. The Order 7 page 32. They have been expressed that the details and paragraph 4, the plaintiff states the paragraph 5 of the plaint that 19th day of January 2026, the plaintiff executed a lease deed in favor of the defendant. It is mentioned that herein that plaintiff has suppressed the fact that he has executed deed on 25th day of August of 2026 in favor of the which is the lease deed being number such and in respect of plot number such and such. Mauja Jamuri and the copy of the said deed is annexed herewith. This is a separate plot number.
Your plaint case is that you had gone there to execute a lease
deed,
which was converted to a gift.
Lord, there are three properties in
Will
total.
dispose of the appeal.
Yes. Lord, there are three properties in total of the plaintiff.
Mr.
Lord,
Kodkar, how can the court rely on this, your Order 7
Lord,
Rule 11?
now, Lord,
Take it as a ground in the defense.
I understand, Lord, but now, Lord, our High Court and other High Courts have also said, relying on Supreme Court, Lord, that Lord, suppression of material facts which are supposed to be known by Lord the plaintiff, if not disclosed or deliberately disclosed, is a clever drafting, and Lord needs to be nipped in the bud.
What material fact has been disclosed?
Yes, Lord, there are three properties in total. Lord, two you have your Lordship has seen, Lord, from paragraph 4 of my Order 7 Rule 11. Lord, my Lord has seen, Lord, two properties out of which, Lord, which are part of paragraph 4 in the Order 7 Rule 11. And the other property is, Lord, the schedule property. These are the three properties. The plaint case, Lord, kindly comes to paragraph 1 and 3 of the plaint. Page 12, Lord. Now, the plaintiff is the father of the defendant, and the plaintiff at all material reposed entire faith upon the defendant. As a matter of fact, the plaintiff became the owner of the property such and such. Lord, the property details is there. Kindly turns over to paragraph number 3. The plaintiff decided to establish his son in his life, and as a result, in the year 2006, the plaintiff decided to execute a lease deed. So, Lord, the entire intention of the plaintiff was to settle down his son with a lease deed so that he can do something in life. That is the basic case of the plaint. Now, Lord, the plaint case thereafter proceeds that as if, Lord, that particular plot of land in the garb of obtaining a lease deed, the gift deed has been obtained. Now, Lord, gift deed was obtained in March 20, 2006. March 25, Lord.
20th March.
No, 19th day of January 2006.
Sorry. Lord, January 2006. On the same year itself, Lord, in August 2006, the lease deed of the other two plots were granted. So, Lord, he knew that. Nobody has challenged that. Now, Lord, if he knows that,
he may have, Mr. Kormkar, he may, the execution of two other deeds in respect of, those are in respect of other plots.
Yes.
That itself rather corroborates his case. That his intention in this case was also to execute a lease deed in favor of you.
Lord, if that is falling
that
from
corroborates his case, there is no question of
Lord, if that is falling from your Lordship,
suppose I am the father.
I understand what is falling from your Lordship. If that is falling from your Lordship,
Yes.
Lord, I go on the month of January to sign a lease deed, I execute a lease deed and register it.
In your
Thereafter,
favor.
Again, I
regarding X plot.
Yes,
regarding
X
X plot.
X plot.
For Y and Z, I go in August or some other month.
Again,
and
that is never the case. Because Lord, if the plot is there,
You are
this particular plot,
you are knitting an entire, you're spinning a network.
Lord, I'll indicate.
That cannot
Lord,
be the
this-
order 7 rule 11 scope.
This suit property is a dwelling house.
How is this German, even if he, first of all, court cannot look into anything apart from the plaint, or we'll look into your judgments if you have any right now.
My lord,
Don't bring on
no,
some.
I had.
Yes. Apart from the plaint, whatever we have learned and whatever order 7 rule 11 says,
cannot be looked.
you have to read into the read at the entire arguments of the plaint as a whole, and you may look at the annexures. At the best, the documents referred to in the plaint.
Meaningful.
You make out a new case, a defense case, sort of, in your order 7 rule 11, saying that there are two other lease deeds. How can the order 7 court look into that order 7 rule 11?
Lord, there are,
Decide it in the suit first.
there are only,
Secondly, these are not in his favor. The suppression is not in his favor. Rather, if he disclosed that he executed other deeds regarding other plots in your favor also later on.
this would not stand.
No, rather it would be corroborated that he is in the habit of executing lease deeds in your favor. And that was also intended to be a lease deed.
Lord, this particular suit property is a dwelling house, Vastu property. And Lord, the other properties which have been with the deed of lease has been
Vastu property father gifted to you during his lifetime.
Vastu
And he will
property,
stay on the
case is,
streets.
Milord, the case is, Milord, he is granting me lease to operate it commercially. So, Milord, if Vastu property is going and they have two.
Where are all these cases made out in the
No,
plain?
that is exactly paragraph 3.
Retail outlet.
Yes.
Achha.
So, Milord, how a Vastu property goes, and he has two properties. One he has already leased out. So, what remains? The Vastu property is going. Milord, that first click should be there.
These are within the scope of order 7 rule 11
But order
consideration.
7
You don't
rule
even
11
understand.
Not order 7 rule 11, our honorable court is saying, if this particular fact was brought in,
How
it
is
would
it?
have affected the
How?
Lord, there are two properties. One is
So you disclose in your written statement.
that is there, but
This is not suppression. Suppose he had suppressed that he had, previous to this execution, he does not have title and he had executed another transfer deed in favor of a third party. And on the date of filing of the suit, he did not have title in the property. Or
No,
that you are not
is-
his son at
that
all.
is on a different.
Something of that level, Mr. Karmakar, would be suppression in order 7 rule 11.
My case, Lord, a plaintiff has two properties. One is
You are
Vastu-
disclosing two other lease deeds in your order 7 rule 11. Say that those have not
No,
been
that is
disclosed.
German because of paragraph number 3. My respectful submission. Paragraph number 3 proceeds on a basis
What
that
would hinge on those two
wanted
lease
me-
deeds? What would hinge on those two lease deeds?
Lord, if those lease deeds were disclosed, if
Suppose
those
they have
two-
disclosed, then what would be the difference?
Then, my lord, in that case, the father was executing a lease deed in the same year for the purpose of exploiting for retail outlet. of
Different
HPCL.
properties.
Different property. Because the
Yes.
other property,
Yes, why
because
would
the
that
other
go against
property
you?
was not fit to be used for retail outlet because it's a dwelling house. So, my lord, if I have two properties, I'm executing, my lord, a lease deed for the retail outlet in the month of January. Again, my son comes in and I execute in favor of my son in the month of August for retail outlet.
Of
I
a different
have two
plot.
properties.
Different
But
plot.
the other plot remaining is a Vastu property. How can it be
Yes.
used for retail outlet?
Can't he execute lease deeds in respect of both his properties so that you can run retail outlet in both the properties?
It's a Vastu property.
Is it
Family
impossible?
dwelling house is there.
From a portion of that you may run.
The portion is not the story made out.
Cannot go
That
into
is
this.
not a
Sorry,
case also.
order 7 rule 11, definitely not. Mr. Karmaka, cite to judge.
And Lord kindly takes the schedule once.
Yes. These are arguments you can advance in the suit,
I
not
understand,
in order
Lord.
7.
Lord kindly sees the schedule.
Yes.
Such and such, having 1150 square feet each, 3 decimal of
Will
land.
flow into the credibility of the cause of action in the in order 7 rule 11.
What is falling from
It's
your
well
lordship?
settled that unless, if no cause of action is disclosed, we can look
If
into that.
illusory cause of action is done.
This does not,
3
this is not
decimal of
illusory.
land. 3 decimal of land.
Yes,
He
see.
is executing it for Millard for opening a retail outlet of a petrol pump. 3 decimal of land. Lord, that's exactly what I'm on before lordship today. It's about clever drafting and illusory cause of action. The suppression.
Clever
was-
argument, cite your judgment.
Not the first. No, the first judgment I'll cite. my lord,
Quick, cite your judgments.
Yes, Lord, I'll. This is
We can't wait
Lord
to
2016.
we can't wait to allow his appeal. No, sir, not that.
2016
But be
1C.
quick in citation of your judgments. Impatient court, lack of knowledge in law. So take your chance quickly. Yes, justice change judgment.
Yes.
Single judge is not binding, first of all.
Yeah, Lord, only to indicate, Lord, that.
So the proposition
reasoning
definitely will look into. Yes. But the
in this case, a suit was filed. Subsequently, an arbitration proceeding was also being continued. The arbitration award came in, which directly hit not the cause of action of the suit. That was not disclosed. An Order 7 Rule 11 was filed, and thereafter the court went on to say that in case the cause of action, the arbitral award was disclosed, the plaintiff would not have been maintainable. So, despite traveling beyond that, the court held the rejected the plaintiff. May I please? Lord, paragraph 2, these are unnumbered paragraphs, Lord. Starts with the plaintiffs have filed a suit for recovery of damages aggregating to 48 crores. Your Lordship has seen that. Lord, thereafter, kindly, Lord, travels to the second page, the last paragraph. On 16th June 2009. On 16th June 2009, Glencore filed arbitration proceedings against STC before GAFTA in London, seeking declaration that STC was not the buyer under the contract. Not thereafter travels. No, these are all facts. I'll just cursorily indicate. Subsequent thereto, on such and such, RPI filed a suit, being suit number such and such, for a declaration that there was no contract between Glencore and such and such. Lord, turns over to page 4. In the middle, your Lordship would find, Lord, Mr. Kapoor has referred, Lord, that portion. Mr. Kapoor has referred to the decision of the Honorable Supreme Court in such and such, reported for the proposition that in such a situation, the court is not powerless, rather it possesses inherent jurisdiction to reject or stay the plaint by treating it complete and by notionally removing the suppression for that purpose. The suppression, according to the London Senior Counsel, in this case is that the plaintiffs have knowingly and deliberately made a statement that no contract has been concluded between Glencore and RPI. It is submitted that such and such, Lord, is there. Kindly, Lord, turns over. In other words, Lord, the noting is in other words, the true principle is that if a plaintiff is guilty to suppression of material facts, then a court has inherent jurisdiction to reject his plaint by taking into consideration the facts suppressed and whether material facts, if inserted, would result in the plaint losing its cause of action. In Maya such and such also considered and approved the principle that courts have inherent discretionary jurisdiction to stay proceedings in appropriate matters where they think it fit to do so. Such a jurisdiction is not limited to cases falling under section 10. The code is not exhaustive, and courts have in many cases where the circumstances warrant and necessities of the case required to act upon assumption of the possession of an inherent power to act ex debito justi and to do real and substantial justice. In other words, when the application for dismissal of a plaint or stay of a suit permanently is based upon a charge of fraudulent suppression of material facts or abuse of the process of law, then then the court is not debarred from considering the suppressed facts outside the plaint. And in fact, it is entitled to see the positive case made out by the defendant, indicating the suppression and or abuse of process alleged against the plaintiff. In Krishnan case, the court laid down that if the ends of justice require it to, or it is necessary to prevent the abuse of process of court, the court has jurisdiction to stay the trial of a, not that's there. Kindly, Milord, turns over to page 6, where the argument of the defendant is that there has been an abuse of process by the plaintiff and the allegation in the plaint are pretense and total fabrication. In such a case, the court is not debarred from looking at the full facts and circumstances of the case presented to it. In such a case, the court has to assess whether or not the frame of suit and its language and the terms are such, and to see if the plaint is orchestrated dishonestly in a way what is a clear attempt to overreach the process of the court or not. If the court finds that the plaintiff is guilty of concealment of material facts, in that event there is no bar for the court from taking into consideration such materials as have been presented by the aggrieved defendant and molding the relief in such circumstances to do full justice in the case. It is the duty of the court in such a situation, on full consideration of the materials on record, to form an opinion if the suit is vexatious or an abuse of the process of court, in the sense that it is a bogus and irresponsible litigation, and in the event the answer is in the affirmative, the court should dismiss the suit in limine. Now, my lord, the argument was made, just, my lord, the way my learned friend is indicating, kindly comes to the page, my lord, 7, the last paragraph. Or contrary, my lord, such and such, appearing on behalf, my lord has kindly got it, my lord. Appearing on behalf of the submits that the application filed by the defendant is misconceived and proceeded on the complete misreading of Order 7 Rule 11 read with such and such. In an application for rejection of plaint, required to find out if on the date of presentation of the plaint it discloses a cause of action, any subsequent event cannot be taken into consideration in deciding the said application. The law with regard to the dismissal of a suit is based on the principle that the reasons for dismissal must exist as on the date or filing of the suit. That is, either the plaint itself has failed to disclose any such cause of action, or there is some material suppression which exists as on the date of filing of the suit. The amendments made in the plaint are only required to be looked into for the purpose of considering an application for rejection of the plaint. In the application, the defendant had alleged that the allegations in the plaint are false and such and such. The defendant thereafter sets out the fact not required, my lord. Kindly thereafter turns to, my lord, page 7, page 9, I'm sorry, page 9. The second paragraph, starting with it is submitted that. It is submitted that cases cited by such and
in the
such.
next two paragraphs also.
Yes.
Page 9.
Lord, your lordship has also seen, my lord, page 10.
No.
Kindly comes to page 10, the merits of the instant application.
Yes.
The merits of the instant application are required to be decided with within the four corners of code. The court has power to reject the plaint under such and also under section 151. Even if the application does not bear the nomenclature such and such, the court, on a meaningful reading of the plaint, is required to find out grounds. Apart from the aforesaid provision, the court can also exercise its power in striking out pleadings if it appears to the court that any part of the pleading is unnecessary, frivolous, vexatious, or abuse of the process of court. The instance of an abuse of the process of court would cover matters where there is a suppression of material fact as on the date of institution of the proceeding, or in a case where a party is relitigating the same issue which has been tried and decided. But if the same issue is sought to be re-agitated, it amounts to abuse of process of a proceeding being filed for a collateral purpose or a spurious claim being made in litigation may also, in a given set of facts, amount to abuse of process. Frivolous or vexatious, Lord, has to be shot down. That is. So, Lord, this is the first judgment, Lord, on. So this is.
Yes.
Yes, Lord, I'll. Karnataka judgment.
How many more judgments, Mr. Kormakar?
Lord, judgments.
Three.
সেলাই করা নেই কেন 2019 3030
In the meantime, indicate to him the next judgment you will decide so that he is prepared. Yes.
Lord, 2019 SCC online, Karnataka, my lord, 3090.
All the rest are other states.
Paragraph.
The rest are other states.
This one, and I have the other of our High Court.
Yes.
And Lord, with respect to abuse of the process of law, I will not multiply, my lord. Those are will be my submission.
Yes.
And one more citation I will make, my lord, on limitation, because 2006, the date of knowledge has to be of the registered, my lord, document.
Yes.
Kindly, my lord, straight away comes to paragraph number 6.
Yes.
If the plaint is subjected to scrutiny, it appears that the plaintiffs have founded the reliefs mainly contending that the GPA such and such was only document executed by them and their father in favor of defendant number 1 and 2. They say that they had to join in execution of the GPA with their father on the insistence by the defendant number 1 and 2. The argument of the petitioners' counsel is that the plaintiffs have deliberately suppressed two important transactions, namely execution of an agreement sale and an affidavit, which were contemporaneous transactions. The petitioners' counsel has produced these documents in the background of well-established principle that only plaint must be seen for deciding Order 7 Rule 11. A question whether these two transactions can be considered would obviously arise. As has been pleaded by the plaintiffs in GPA was the only document that came into existence as such and such, definitely the plaintiff's case that they are entitled to 1/3 share such and such becomes an issue to be decided after recording evidence. If not, they must fail at the threshold. Now, if para 10 of the plaintiff is meaningfully read, what plaintiffs have stated in that GPA is an independent transaction and no consideration was paid for the execution of the said GPA. That means they do not want to state anything about agreement of sale and the affidavit. The plaint appears to have been drafted cleverly, suppressing the material facts. The court in a situation like this has already taken a view in case of such and such that suppression of facts by the plaintiff may be a ground for rejection of plaint. Lord, the quotation is there. Paragraph number 7, Lord, it was allowed. Now, Lord, my case is also on the same footing. Lord, here I say that if the factum of Lord the lease deed was produced at the time of disclosed at the time of filing of the plaint, then Lord, the story that Lord the sale deed was executed in the garb of executing lease deed would have taken a not go by.
Why? We
That
can't
wouldn't have
understand
existed.
why.
Lord, again, I
Can't
say
one
that
execute
paragraph, I
separate
can
lease deeds
always I can.
regarding
The
different
purpose of the sale deed as per the plaint is for opening a retail outlet. 3 decimal of land.
The other two lease deeds were executed also for opening retail outlet.
Yes.
So if 2 can be opened, why not 3?
No, those are first is not those are for commercial classification of land. One. Second is about the area of land, and those two lands are situated in two different places. Lord, I could have understood, Lord, that a portion of from the Bastu property is being given for lease for opening the balance portion of the retail outlet. Here is no such case. 3 decimal of land, Lord, it runs completely contrary to what paragraph 3 of the plaint says. Now, Lord, the other is Lord 2022 volume 2 Supreme Court cases 128.
We told him to be ready with the matter, with the copies.
Is there? Lord, paragraph number 15 to 17. This is on the point, Lord, that date of knowledge. So the previous paragraphs are also there, Lord. I will not bother your Lordship. The issue was the same, Lord. A sale deed here was sought to be, Lord, cancelled. And the date of knowledge was given in the plaint that I came to know because of this particular reason. Paragraph 15 deals such and such. It is observed that and held by this court that where there is a dispute that the suit is filed beyond the period of limitation, the plaintiff would have to aver and prove that the suit is within the period of limitation as prescribed in the absence of any averment or proof to show that the suit is within time. It is the plaintiff who would fail. It is further observed that whenever a document is registered, the date of registration becomes the date of deemed knowledge. This is admittedly a document of 2006, registered document. Subsequently, again, Milord, 2 other registrations have taken place. And other factors are there, Milord. Let us not get into that for the time being. Yeah, you know. It is further observed that in other cases where the date of where the fact could be discovered by due diligence, then deemed knowledge would be attributed to the plaintiff because a party cannot be allowed to extend the period of limitation merely claiming that he had no knowledge. Applying the laws laid down such and such, the court decision to the facts of the case on hand, it is noted that the registered sale deed in favor of defendant number 175 and thereafter immediately the name of defendant number 1 purchaser was mutated in the revenue record. Not same case here also, which continued till the filing of the suit, and the name of the defendant number 1 is shown as an owner and cultivator, and even the crop grown is also shown. And when the plaintiff claims that she is in possession and cultivating the land, she would have known above facts if she had exercised due diligence, and therefore, as observed by this court, the plaintiffs can be said to have deemed knowledge of the title as well as possession of the defendant number 1. It is to be noted that even in the registered sale deed, it is mentioned that the possession of the entire land in question has been handed over to such and such. At this stage, it is required to be noted that the execution of the registered sale deed and the payment of full consideration not required. Therefore, was no reason for trial disbelieve the averments in the registered sale deed handing over of possession. The relief of permanent not required. Therefore, once the suit is held to be not suit for permanent injunction, whatever that there was. So the last is, my lord, our High Court on
That's it. You don't know. Also, getting question of value.
But the plaint case here is suddenly he has come to know, Lord, that in 2022, Lord, I was trying to throw him out. That's why he filed the suit without knowing that he had executed a gift deed. He was the person doing that, deemed knowledge. Lord, it's there.
Yes.
Lord, the last. আমি
Yes.
দাদা এটা আনরিপোর্টেড আমি পড়ে দিয়ে দিচ্ছি।
Yes.
An order dated some paragraph 1. The learned court had rejected an application filed by the defendant under order 7 rule 11. The other part of the order rejecting an application such and such is not subject matter of the proceeding. So, this was the case. The defendant prayed for rejection of the plaint on the ground that the plaint did not disclose a cause of action. The suit was not maintainable under 22 such and such. The plaintiff did not have a preferential such and such. The share of the plaintiff was never denied, as would be evident from the, as such, a suit for declaration and permanent injunction would not be maintainable, and thereafter so long and so forth. For the relevant portion, Lord, kindly comes to page 9, Milord, paragraph number 18. Moreover, the plaintiff talks about the Ichhapatra but does not talk about demarcation partition of the suit property. Here also, Milord, the same thing happened. The suppression was there. The pleading is incomplete and inadequate. The other paragraphs clearly indicate that the plaintiff had accepted the petitioner to be co-lessee, having his undivided share in the property along with such and such. The plaint, paragraph 19, the plaint discloses a letter written by the petitioner to the plaintiff. Such letter indicates that the petitioner had intimated the plaintiff about his desire to sell the undivided portion in the property. The petitioner further intimated the plaintiff that the lease deed did not prohibit the petitioner from transferring such. No contrary pleadings appear from a reading of the plaint. Only by mentioning an Ichhapatra and the lease deed, a cause of action to sue could not be established. The pleadings are vague and insufficient. Without proper pleadings as to how the right to sue accrued, the suit is not maintainable. Incorporation of such facts in a casual and cryptic manner was only to create illusory cause of action. Illusion. Lord, kindly. Lord, kindly comes to paragraph 26. No, I'm sorry, Lord, paragraph 23 would also be important, Lord. The present case is a classic example of clever drafting. the plaintiff attempted to create a illusory cause of action in order to bring the suit within the purview of section 22. Such a remedy under such and such is an independent and special remedy wherein the court is empowered to summarily dismiss a suit threshold without proceeding to record evidence and without conducting a trial on a basis of evidence adduced, such and such. In this case, the plaintiff does not disclose a cause of action to maintain such and such. An inapplicable provision of law has been pressed in such and not
Para 40 also. Intentionally omitted to mention.
I'm grateful, Lord.
And para 42 also does not disclose any cause of action to sue.
To sum up, Lord, my first attack to the plaintiff was with respect to limitation because 2006, Lord, there is no explanation 7 except one paragraph saying that, Lord, came to know because when the defendant came to throw him out. That's one point which you cannot take under the regards of that.
Limitation act. Yes.
My second argument before submission, Lord, before your lordship was that, Lord, if the fact of lease deed was disclosed, then the story run in the plaintiff would have taken a complete backseat. The cause of action would have seemed to have evaporated.
You stress on the that the lease deeds were the same year. Lease deeds were executed. Other lease deeds were for a different places.
Also the purpose.
Same
But
purpose.
I'm stressing on the purpose.
Same purpose.
The gift deed was given to me, Lord, with respect to the family house.
No. Their case is that lease was sought to be. You made out a case that he was executing a lease deed for retail outlet.
Yes. No,
and the actual lease deeds were also for retail outlet.
Yes.
So the same.
Whereas his plain
You
case
say that
is,
the area were first of all the area is small. This property. Those areas were larger.
Yes.
Secondly, that those were in different places.
Yes.
And in the same year in three places for same purpose, probably that is also
absolutely.
Very well.
So this is a complete result of a clever drafting and illusory cause of action, hid by limitation. Lord, and one more thing, Lord, I must indicate to your lordship, section 50, article 59, my lord, also.
We are there. No, you did it. You make
When
it
the
sufficient.
3 years, when the facts entitling the plaintiff to have the instrument or decree such and such cancelled or set aside or the contract rescinded become known to him, and known is deemed knowledge because of 2006. Similar that these are my respectful submissions.
Yes, anything else? Want to add?
My lord, I'm relying on judgment.
You are relying on a judgment in reply.
No, reply. My lord, in case of my lord, the clever drafting, my lord, the court has to see the searching the under order 10 CPC. Has to see the searching the under order 10, examining the plaintiff. What is the clever drafting or not? This is, my lord, the one point has been, my lord, the
which judgment?
Supreme Court, my lord, the page paragraph.
Unreported judgment.
Reportable judgment. I have obtained from the online.
No, you cannot cite a new judgment in reply. Sorry, you have made your arguments. No new judgment in reply.
This is the only point. And my lord, the article 59, from the date of knowledge 2022, I have got the knowledge, and thereafter my lord filed the suit. That is article 59.
এখন judgment দেওয়ার টাইম হবে না, মিটিং আছে 7 মিনিটে চেঞ্জ বলে দেবেন এগুলো যেন সঙ্গে সঙ্গে দিয়ে দেয়। Okay,
Even Malad, I appear for the appellant. But this is coming up after service. Well, this appeal may be disposed of because well, nothing remains in the appeal. If your lordship remembers, but it is with regard to the election procedure and well, who would operate the bank accounts. Your lordship kindly takes up your lordship's last order. Well, it may be made absolute.
Addressee ke serve করেছে দেখেন। It's not written that the addressee has been served, only the DC, Bodisha DC. Nowadays, this is being given.
Yes, ma'am. Because this order in any event does not prejudice anybody because your lordship remembers the bank operations are to be done by two people, my lord.
We cannot make it. We'll make we'll dispose of the application, but the appeal cannot be disposed of without them because we did not give them notice of appeal. This we directly to serve copy of the application only. Despite service,
No, we have served both. We have served both.
Despite service, none appears for the respondents at the time of call. Full stop. Next para. The appeal arises out of an order allowing the defendants stroke respondents apostrophe application under order 39 rule 4 of the code of civil procedure, comma, by allowing the erstwhile president of the defendant number 1 society to operate the bank accounts of the said society. Push up next para. The appellants argue that the impugned order was beyond the prayer made in the vacating application, comma, which was for the president and the treasurer to operate the bank account of the respondent number 1 society. To sub next para, upon a full-fledged consideration of the regulations of the council, comma, by an order dated December 15, 2025, comma, we had granted ad interim stay of the impugned order with a rider that both the president of the erstwhile council as well as the treasurer thereof shall be entitled to operate the account in question. For sub next para, since no subsequent change of circumstance has been pointed out to us, comma, the said order is made absolute. Full stop. Accordingly, can 1 of 2025 is disposed of by granting stay of operation of the order impugned herein, comma, with the rider that both the president and the treasurer of the erstwhile council shall, comma, in terms of the prayer made in the application under order 13 and rule 4 of the code of civil procedure made in the trial court, be entitled to operate the account in question, that is the bank account number 20014820804 held with the Indian Bank, comma, Kolkata main branch in the name of the respondent number 1 hyphen council. For sub next para, in view of the scope of the appeal and the application being similar and short, comma, formal filing of paper books and calling for the records is dispensed with. For sub next para, the appellant shall serve a notice on the respondents, comma, along with a server copy of this order, indicating that the appeal and the application shall be listed under the same heading. Application to dispose. That the appeal shall be listed for hearing in the monthly list of February 2026. Such notice shall be deemed, such notice, comma, if served, comma, shall deem to be a notice of the appeal. Other formalities are dispensed with.
Technically, nothing remains, but
nothing remains.
That's my lord, we have
that's why we have, because this order continues.
Yes, this order continues.
It's there on
That
us
is
now
the
to
only
come and
scope of the suit itself.
yes, it's there on us now to come and mention the appeal because they are suffering. Not even suffering.
Not even suffering.
If that notice is served on them, we have directed it to appear in the list. So you can mention, we can put it as to mention and decide if they agree to this.
Yes.
Tell them if they agree because it's their prayer we have announced.
Yes, they have prayer.